Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3. Test.
Even behind, I think. We're gonna want him to take everything.
Are we okay?
All right. Okay.
All right.
Morning, everyone. The court wishes to thank, and appropriately so at the outset here, the Indiana University McKinney School of Law for hosting this special session of the court. It's great for us to be here. We've received a very warm welcome. Many members of the law school that have had a big part in putting today's session together. And we want to acknowledge the law school's dean, Karen Bravo, the assistant dean for external affairs, Liz Arlington, has worked very hard helping us with this session, as well as her assistant, Barb Becker, law school's Professor Joel Shum, has also been important in making today happen. It's a special privilege, most especially for this panel, to hear this morning's cases at the law school. Judge David Hamilton, of course, practiced in Indianapolis, served on the district court here in Indianapolis, including as its chief judge before joining the Seventh Circuit. And our most recent member of the court, our colleague, Judge Doris Pryor, of course, practiced in Indianapolis before joining us quite recently, late last year. And so it's a special delight. And myself, I call Fort Wayne, Indiana home. And so with this all Hoosier panel, if you will, assembled, we'll begin with the first of 6 arguments this morning. And we'll start with case number 22-1466, the National Wildlife Federation versus the United States Army Corps of Engineers. Mr. Volker, good morning.
Good morning, Your Honor. It's a pleasure and an honor to be before the Honorable Court this morning. Thank you very much. If it please the Court, my name is Stephen Volker. I represent the Conservation Coalition appellants. We seek review of 2 rulings by the District Court. One, that the Water Resources Development Act of 2007, 33 U.S.C. Section 2283D, did not require the defendant Corps of Engineers to prepare a specific mitigation plan before approving its Mississippi River Regulating Works project. And 2, that the Corps' supplemental EIS for the project was adequate. Sections 2283 D1 and D3 require specific mitigation plans with many specified components for damages to ecological resources, including terrestrial and aquatic resources and fish and wildlife losses resulting from federal water resources projects. For 2007, mitigation plans were required only for one category, the submission of any proposal for the authorization of any water resources control project to the Congress in any report. In 2007, Congress added, quote, and the Secretary shall not select a project alternative in any report. The word and, I should point out, is additive, because here the Corps issued a report which selects a project alternative, the supplemental EIS, which selects the project, and the project will have greater than negligible adverse impact on ecological resources. The Corps was required to include a specific plan to mitigate for damages to ecological resources created by such project.
Mr. Volker?
Yes.
Can I ask you, so we got an interesting puzzle for the statutory interpreters here. Given arguments, material for both sides. Let me start with a hypothetical. Suppose what we were talking about was a record of decision that used an environmental assessment and a finding of no significant impact on the environment. Would such a, quote, report have to include the detailed mitigation plan that you're arguing would have been required here?
Perhaps not, because the key here is whether there will be more than negligible adverse impacts on the environment. And typically with an environmental assessment finding there's no need for an EIS, there's a finding that there is no significant or potentially significant environmental impact. So by and large, environmental assessments would not trigger the requirement.
I
However,
could easily imagine, however, somebody opposing a project arguing that those are two different phrases for no significant impact, and what's the one here for under 2283, the minimal, no more than minimal.
negligible,
Negligible,
yes.
sorry,
Mhm,
yeah.
yes.
But those are different standards, and so there's room to split the difference, and that you'd have to be have a mitigation plan for an environmental assessment.
Well, I agree with the court that in the event that the statutory standard were satisfied, yes, a mitigation plan would be required to provide for avoidance, minimization, and compensatory mitigation for impacts that the environmental assessment identified as falling within the statutory standard under 2283 D1. So we cannot overlook the direction by Congress here, which was pretty broad. As the court is aware, the rule of statutory construction is that when a statute has been amended, which is unusual when it's of this scope, the presumption is that Congress intended a change in the law. And
right.
here,
So what do we make of if the Senate bill had been adopted, you probably win, right? Which that language specifically referred to requiring mitigation plans for environmental impact statements and environmental assessments and so on. The conference committee backed off of that language. What significance does that have for us in interpreting this phrase?
the significance is insofar as one is, first of all, compelled to implement the plain language of the statute, then the plain language governs.
It's not plain. I mean, let's start with that, okay? I understand your position, but I don't think it's plain on this point. So given the history of the Senate language being changed in the conference report to something different, what do we make of that?
Well, the conference report, as we indicated in our brief, confirmed the expansion of the mitigation mandate. It stated, the increased mitigation requirements apply to all new studies and any other project that must be evaluated for any reason. So that reflects the approval of...
Evaluated for whom? For the general public, for internal staff reports? What's the scope of that?
My understanding would be that as in the case of any public document, the public has access to it. And here where there was a supplemental EIS, clearly the public had an interest in reviewing the document, and the Corps had a reciprocal obligation to assure that that interest was addressed fully. That did not happen here, Your Honor.
Well, I think you may have missed the point of my question, which was, the question is, in essence, why do those kinds of reports, and even internal reports, presumably under your broad reading of the language of the statute, have to include that mitigation plan rather than just mitigation reports going to Congress, which has to do all these kinds of project evaluations itself? So.
Well, in this case, the supplemental EIS was circulated to thousands of members of the public and agencies, and prompted hundreds of responses from agencies and the public. So clearly we're talking about a document of some moment that was in the public realm, and accordingly the need to attend to the mitigation plan requirement that had been changed in 2007 is uppermost. That's the first order of business, both under WRDA 2007 and under NEPA, is that where there is the potential to mitigate an environmental harm, that the agency has an obligation to examine alternatives or mitigation measures that would provide a pathway to mitigate that harm and still achieve the objectives of the project. The goal is a win-win, to provide that needless harm to the environment
right
avoided.
right now. But Now, the Corps has been interpreting this language since 2007 as applying only to reports to Congress, right?
That would be incorrect, with all respect, Your Honor. May I elaborate?
Please.
Yes, okay. On pages 27 to 28 of our appellant's opening brief, we listed 4 implementing regulations for water resources projects that use the term reports to describe documents not submitted to Congress. That would be at 33 CFR sections 209.140, 230.15, 385.12, and 385.26.
I understand the regs and the statutes are not consistent in the way they use in term reports. Sometimes they're more precise, sometimes they're less. But with respect to the mitigation requirement in 2283D, I understood the Corps' memo from 2007 to be saying this applies to reports to Congress. Am I misunderstanding that?
Yes, the implementing regulation was amended by the Corps of Engineers to basically back engineer its misinterpretation.
No, I understand you're unhappy about it. Did they interpret it that way in 2007?
I believe that it was subsequent to 2007,
Okay.
Your Honor, but at
Very
some
recent.
point,
Shortly after the amendment took place, right?
they adopted a regulation which provided a basis for maintaining that position, yes.
Yes, okay. That's about 15 years ago. Has there been any pushback from Congress? Say, no, you misunderstood this. You know, committees that are responsible for these kinds of things have pretty close communications with agencies like the Corps. Do you have any indications that others have been unhappy with this?
Personally, I'm not abreast on matters of that nature, but my client, the National Wildlife Federation lead client, is aware that there has been a lot of activity in Congress reflecting a concern about this, but I can't.
Mr. Volker, let me ask you a different question about the statutory scheme here. Can you cite any provision in the 2007 Water Resource Development Act where Congress used this term report? They used it in a way to include an environmental impact statement, but they didn't say that's what they were doing. And the reason I'm asking you that question is because when I look at the public law document and I look at amendments, for example, to section 2346 in Title 33, amendments to 2215A, when Congress uses the term report, in the text of the statute, they are very clear to say that by that use of the word report, we are including environmental impact statements, but they do not do that in 2283D3. So shouldn't the court take some direction from that statutory structure? The way Congress is using the report in some areas of the statute, but not others.
Actually, I would construe it exactly the opposite as from the interpretation that Your Honor has suggested, and the reasons are twofold. Number one, Congress used the term any before the word report. The word any means every. It's the broadest possible formulation in the English language to comprehend all types of reports. It didn't say reports that are included in proposals for authorization to Congress. That would have been the perfect way to achieve the objective had Congress had in mind that the clause added in 2007 was limited to proposals to Congress for authorization.
I understand that's your argument, but I didn't hear an answer to Judge Scudder's question.
There are four places in the statutes, in the wordas, that
No what?
Water Resources Development
Oh, okay.
Acts.
All right.
I'm
got
sorry.
Okay, I got it. Go ahead. Keep
It
going.
was odd. There are 4 places, at least, and there are probably others. We did not do a comprehensive survey, just sufficient to make clear that Congress was not routinely adopting a narrow construction of the term report. In 33 USC 2282B5, Congress included within the term, quote, report, close quote, a report to a non-federal interest. So clearly that's not a report to Congress. It's not a report that's part of a proposal for authorization. In section 2282A4, Congress included the term environmental impact statement in its definition of feasibility report. So that suggests that there was no uniform restriction of the term report to exclude environmental impact statements. In section 2282C, Congress used the term report to describe project-related studies not sent to Congress for authorization because they are implemented through one of the Corps' continuing authorities programs. So with a little understanding of how this works, there are matters that are within continuing authorizations that are not submitted to Congress. And this is an example where Congress used the term report with the understanding that report was not restricted to proposals to Congress for authorization. Then also in section 2346, which the court mentioned, that expressly includes the term environmental impact statement among the documents within its heading, report repository. So those are 4 of perhaps many examples where the term report was not used by Congress, and it certainly wasn't used by the Corps of Engineers in its implementing regulations to restrict the term to proposals for authorization to Congress.
Okay, Mr. Volker, do you want to reserve some time for rebuttal?
Can I just ask one much broader question, Mr. Volker, and that is, in essence, what do the plaintiffs want in this case? What do you want the Corps to do with this stretch of the Mississippi River?
Yes, thanks.
Rather than just keep it open for barge traffic?
Well, obviously we support the use of this critical part of the nation's commercial waterways to protect commerce. No doubt about that. We are fervent supporters of that. However, we're trying to achieve what we believe is Congress's intent to assure that the good efforts of the Corps of Engineers to maintain that navigability also embrace Congress's direction that there be mitigation, that is, avoidance, minimization, and compensatory mitigation where it's possible. And the best way to do that is to adhere to Congress's direction in 2283 D1 and D3 to prepare the mitigation plan required. And as the court is aware, D3 requires 6 specific components.
What do you want them to do?
To do the plan.
What do you think? What do you want that plan to provide for in terms of physical alterations to the river?
We wouldn't presume to know what physical alterations are required. That would be beyond our ken.
The plan.
That's for the engineers and the ecologists.
I thought that's what you might say, and the difficulty that I have with that is how you align that position with Congress expressly authorizing a programmatic approach to mitigation. In other words, looking at mitigation more in installments, not with respect to the whole 195-mile stretch. It's expressly in the statute in 2283H. In other words, it seems to me that your objection is much more with Congress than it is the Corps.
Well, we're trying to follow the direction of Congress by looking at its language, and the language in 2283 D3 identifies 6.
No, I know that, but when Judge Hamilton says, what are you getting at? and you say we want a mitigation plan.
Yes.
Congress has said we allow the Corps to do this in plans, plural, mini plans, as part of a programmatic approach to take segments or installments of the Middle Mississippi River, and then to really focus on the environmental aspect of what's going on in that segment vis-a-vis a construction proposal or dredging or anything else.
Well, the short answer would be the programmatic reference in subsection H does not amend or exempt the requirement in
No, but of course it doesn't. But you need to read it as a
D3.
whole. You need to read the statute as a whole. I mean, you don't think we're not inclined to read H. The very same Congress that put H there put D there. I think that they're not going to work at cross purposes with one another. They're going to work in harmony with one another.
Well, may I respond?
Sure.
Okay, thank you. 2 points, Your Honor. First of all, neither the notice of the draft EIS or the notice of the final EIS or the titles of those documents use the term programmatic. So as a technical matter, although they had language about the broad scope of the assessment, they were not, technically speaking, programmatic EISs. Secondly, I agree with the court that one has to look at D3 and H together, as is required whenever one's examining a statute, and I believe they can be harmonized because D3, the requirements in D3 to provide for identification of ways, whether it's on a programmatic basis or a site-specific basis, of identifying less impactful measures. The overall context, if I could just take a step back, is that we have in the last 30 years, I think there are 48 independent scholarly works that concluded that the regulating works program was having a deleterious impact on fish and wildlife, and that there was a need to take a look at ways to modify the project. And of course, we have statutes, the 1990 WRDA, the 2007 WRDA, the 2014 WRDA, the Fish and Wildlife Coordination Act, and we cite sections from all of those that make clear that Congress was concerned about the loss of ecological health in the Middle Mississippi River and was adopting programs directing the Corps of Engineers to look at mitigation.
But isn't there a cost sharing requirement?
The cost sharing requirement, I think, has been the source of some confusion, but it's unjustified. The governing statute is in 33 U.S.C. 2283C, which refers to fish and wildlife mitigation and allocation of mitigation costs. It says costs incurred after November 17, 1986 shall be allocated among authorized project purposes in accordance with applicable cost allocation procedures and shall be subject to cost sharing or reimbursement to the same extent as other programs. This project is a 100% federally funded, federally mandated program. The Regulating Works project being 100% federally funded, the mitigations of its impacts are also 100% federally funded. There is no local partner sharing in the cost. This does not involve any contribution by anyone else, and that's never been a requirement. And the Corps' implementing regulations confirm that in the Planning Guidance Notebook, which is ER 1105-2-100.
Mr. Volker, we'll let's do this. Let's move to the Corps, and we'll get no need to apologize. We'll give you a couple minutes for rebuttal.
That's very kind. Thank you, Your Honor.
You're welcome. Collier, good morning.
Good morning, Your Honors, and may it please the Court. Amy Collier on behalf of the federal defendants. I think it would be helpful at the outset to provide a little context about what the Corps is doing on the Middle Mississippi. So Congress has long recognized both the importance of a navigation channel on this stretch of the river.
Connor, can we jump to 2283?
Yes. Yes. And so I think as the district court found, the district court focused on 2283D, but I think it's also important to look at 2283A and subsection B. So subsection A provides that the Corps must mitigate
Was the
for
argument of
projects.
subsection B raised in the lower court?
It was not directly raised in the lower court. It was raised throughout the SEIS, and I think it just provides context for why subsection D is not applicable. I would also note that in plaintiff's appellant's opening brief on page 16, they mentioned that the Corps was authorized in the 1986 WRDA to engage in mitigation, and that sort of comes from subsection B. So subsection A again says that the Corps must mitigate for projects where construction has not commenced as of 1986. Subsection B then provides the Corps with discretion to mitigate for projects whether under construction or not. So the Corps
argument that this is a 2017 project, so therefore it couldn't have started before 1986.
So I think it's important to keep in mind the term water resources development project. Only Congress can authorize a water resources development project, and Congress did so for the Middle Mississippi in 1910 and modified it in 1927. And you can see for example, in the language in the 1927 Act, Congress referred to it as the existing project. In 2014, in that Water Resources Development Act, Congress referred to it as the project for navigation. So again, Congress is treating the whole regulating works project as a project. What the 2017 SEIS, Supplemental Environmental Impact Statement, did was the Corps saw that, there's new information about the impacts that this larger project is having. And so we're going to step back, we're going to study those impacts and determine whether to continue with construction, that is one of the alternatives, or whether to stop all construction. And so the position is that the subsection B's discretionary provision applies. And consistent with that discretion, the Corps did prepare a mitigation plan, one that's consistent with a programmatic analysis for this.
That's 2283H.
So the Corps did not prepare the mitigation plan pursuant to subsection H because the Corps had not yet prepared implementing guidance for that subsection when it was working on the SEIS. Our position, though, is that the existence of subsection H, which was added in the 2014 WRDA, is showing that Congress does have a different sort of understanding for how this is supposed to apply to programmatic studies. And so the Corps' position is that it will prepare tiered environmental assessments off of this SEIS. In fact, it has already done so. And those will contain detailed mitigation plans that will, look at the structures that are being proposed, use the Corps' newly developed border habitat model to sort of assess what those impacts will be, and then craft a mitigation plan that will directly address those concerns.
Ms. Collier, is that a way of saying that the Corps is approaching this from a mitigation perspective, pursuant to and within the confines of H from here forward?
I think that's a fair representation. I wouldn't say directly that the Corps is engaging with everything in H, because again, I think mitigation still remains discretionary for this project under subsection B. But the Corps has committed in the continuing construction alternative to engage in mitigation to the greatest extent practical going forward, and has plans, as it has already done so, to prepare mitigation plans when construction is actually proposed at the site-specific level. And I think it's helpful, again, to look at subsection D in the context with subsection B. Again, subsection B provides that discretion. It would be a little illogical for Congress to mandate the preparation of a specific mitigation plan for a project where mitigation is in fact discretionary. And so again, our position is that it applies to both proposals for new projects under the first clause, and then also for any reports seeking a reevaluation of a project.
Both of these also, I'm sorry, do we agree though, when we're looking at the 2283D language, that under both categories that you just described, that it would have to be submitted to Congress?
I think in the context of this statute, yes, that was Congress's intent, that it would be something submitted to Congress. So when Congress is deciding whether to authorize a new project or to modify an existing project, it has all the information in front of it, including the plan for how the Corps is going to mitigate those impacts. And I think it's also important to look again at the specific language. Appellants focus on the word any, but of course the language also uses the term report. And as your honors have pointed out, throughout the 2007 WRDA and subsequent WRDAs, Congress has specified the use of environmental impact statement or record of decision in places where it wanted report to include that term. And to go to Judge Hamilton's questions for appellant, so the Corps' implementation guidance was issued in 2009. Since then, Congress has passed 5 additional WRDAs, including at least a few since the 2007 SEIS was issued, and Congress has not amended 2283D to expand it in any way.
Can I ask you, Ms. Collier, I want to focus on the statutory phrase about selecting a project alternative. In what documents does the Corps select a project alternative?
Certainly. So the Corps refers to selecting alternatives, for example, in feasibility reports. So that's 33 USC 2282.
Now, that is one that includes report EIS.
It includes associated environmental impact statements, but it also explains that it includes, the feasibility report shall describe, and then it says, and a recommended plan and alternative plans considered by the secretary. I would say in places where it lists out environmental impact statement, it never says that an environmental impact statement on its own constitutes a report. So one prepared, for continuing construction that's not submitted alongside any report to Congress, it never says that that alone constitutes a report. It's just in the context of some sort of other proposal. Or, for example, so reevaluations of project. If the Corps is going to go back to Congress and suggest that there's some reevaluation of existing project to modify it, it'll present alternatives.
Okay, but let me re-ask my question. In what documents does the Corps, quote, select a project alternative?
Well, I would say in feasibility reports and proposals to Congress in that sense. The environmental impact statement does not select a project alternative. It selects a preferred alternative or identifies a preferred alternative, but it is really an environmental analysis of the impacts of a project.
Not a decision.
Not the environmental impact statement.
What about the ROD, record of decision?
So the record of decision identifies, again, the preferred alternative as the continuing construction alternative. But the Corps does not treat that as a report that selects an alternative. It's a record of the decision for how the Corps is going to proceed. And I think it's important, again, to look at this document as a supplemental environmental impact statement. The Corps was at a point in the construction of a project, and it was deciding whether or not to continue with constructing the project or to stop all new construction and maintain the channel through the existing structures and dredging. So it's a somewhat fine line there, but again, it's a record of decision for the Corps identifying the preferred alternative.
That is a fine line. Okay.
So I would just add again that, the Corps has, been in dialogue with Congress about this project for 100 years. It is an ongoing project. Congress recognizes the challenge of maintaining this channel. It has authorized the Corps to maintain a channel of specific dimensions, again, using river training structures to reduce dredging. Since the 2007 WRDA, Congress has continued to fund construction. Congress has not modified the purpose of this project to prioritize environmental protection. Nevertheless, the Corps has continued to work with other agencies to develop innovative structures, to implement those innovative structures to reduce impacts to the environment.
Can I go back into the weeds of 2283D and the 2007 amendment? I'd like you to try to explain to me what you think the effect of the final conference language was, how it changed pre-existing.
From the Senate version or the language about?
From the 2006, the earlier version of the law, which referred only to in any report.
Yes. So actually, I would like to make one point of clarification. So before 2007, Section 2283D said that the Secretary shall not submit any proposal for the authorization of any water resources project to the Congress unless such report contains. It didn't have the in any report. So in 2007, then again, so that was specifically clearly for proposals of water resources development projects.
And my question in essence is, what do you think 2007 amendment changed?
So what the 2000 amendment changed was it was to broaden it to not just proposals for new water resources development projects, but for other sorts of reevaluations of existing projects. So for example, that's why the language cited by appellant says, or projects that must be reevaluated for any reason. Reevaluation is a term that's used in WRDA to describe sort of coming back to Congress to modify an existing project. And so it was expanded to include those sorts of reports that would suggest or identify alternatives for modifying an existing project. That's not what the Corps has done here. The Corps has not prepared a report to Congress to modify the water resources development project. It is in fact continuing construction with the project as it was authorized by Congress.
As part of this dialogue, I assume appropriations are a big part of that, right?
Yes.
Okay, and we have, the briefs don't talk about that process much at all. But I assume that Congress is having to appropriate year by year, or at least specific site by site, do this, do that. This legislation is very, very specific.
Yes, Your Honor. And so the Corps process is typically with Congress, it'll authorize projects separately from the appropriations. So Congress has appropriated funding for specific sites along the Middle Mississippi. And the Corps has used that construction funding in various ways to both build these new structures, prevent channel cutoffs, and going forward has implemented the mitigation measures.
All of that occurs though pursuant to the existing project.
Yes, Your Honor.
There's no alteration of the underlying project. It's just a continuation of, in light of current needs and circumstances.
Correct, Your Honor. And I would point out again in the 2014 WRDA, Congress referred to it as the Project for Navigation. As we detail in our brief, after the 1976 EIS was prepared, the Corps had a proposal to change the authorization of the project. That was not something Congress has adopted. And so here we have a clear directive from Congress in both those early 1910 and 1927 acts, but we also have a subsequent history where the Corps has been in dialogue with Congress, where Congress has funded specific projects. Congress has repeated.
Council, can we transition a little bit to the National Environmental Policy Act? You will have another opportunity to address that. Can we talk through why you believe that the purpose statement is sufficient?
Sure, Your Honor. So again, this project was authorized in the 1910 Rivers and Harbors Act, which stated that the Corps shall obtain a channel that was 300 feet wide, 8 feet deep, using river training structures, reducing dredging. That project was modified in the 1927 Rivers and Harbors Act, which stated that the project was modified in accordance with the recommendations submitted by the Chief of Engineers in letter to the chairman of the committee. Plaintiffs do not argue that the Corps shouldn't be looking to this authorization. Instead, they rest their argument entirely on a misinterpretation of what that authorizing legislation said. So the chief's letter is the first couple pages in the document that we included in our supplemental appendix. That is the operative document that the Congress was focused on. They specifically said the letter that from the chief. In other parts of the same act, they said the document submitted. And the chief's recommendations specifically say that the Corps should obtain a channel that's 300 feet wide and 9 feet deep, again, using river training structures, reducing the use of dredging because it provides only temporary results on this section of the river. That's exactly what guided the Corps' purpose and need statement here. And it was very reasonable. Plaintiffs don't disagree that it was reasonable to look
We
at that.
transition just to the reasonable alternatives. The argument is that the scoping, that in particular the Corps has been summarily dismissive of the scoping idea because they would have to go back to Congress to request additional funding.
If I may answer here. So the Corps, had this clear directive from Congress, add a supplemental EIS. As we detail in our brief, it went through various alternatives. It incorporated some of the things that plaintiffs said, and it specifically explained why it thought certain alternatives were not reasonable. So for example, the alternative that would seek a purpose change, for one, the continuing construction alternative does incorporate measures to protect habitat while also ensuring that the Corps maintains a reliable channel. Plaintiffs don't explain how the Corps could prioritize environmental impacts and maintain the channel in a different way than the Corps is saying it will do. Courts have also said that agencies need only consider an alternative that requires congressional action in very rare circumstances. And here, where we have a clear directive from Congress about what the purpose of the project is, reaffirming as recently as 2014 that it's for navigation, it was not unreasonable for the Corps to look at what Congress has said and find and consider it that unlikely and speculative that Congress would amend the purpose of this project to prioritize environmental protection. Thank you, Your Honors.
Okay, thanks to you, Ms. Collier. Mr. Volker, we'll give you a couple minutes, 2 minutes. Any final thoughts you have?
First, I wanted to elaborate on the subsection H issue. If one examines H, one finds under subsection 2, use of mitigation plans, the Secretary shall, to the maximum extent practicable, use programmatic mitigation plans developed in accordance with this subsection to guide the development of a mitigation plan under subsection D. That makes clear that H is not intended to be a substitute for or to displace the requirement, the mandatory requirement for a mitigation plan under D. Furthermore, H is discretionary, so it cannot begin to replace a mandatory duty under D. With regard to NEPA, we had a couple comments, as we explained in the briefs. Where an agency receives requests from the public to address reasonable alternatives that would reduce environmental impacts, the agency is obliged to examine them, to study, develop, and describe them in the classic words of NEPA, and may not evade that duty. There are a number of cases, for example, the Southeast Conservation case out of the Ninth Circuit that we cite that specifically say it's improper for an agency to consider an alternative only in a response to comments and only for the purpose of explaining why it rejects it. The agency has an independent duty to study, develop, and describe the alternative, harkening back to the Bob Marshall Alliance cases 30 years ago. So here that didn't happen. And as a consequence, alternatives that the public in good faith had presented in the hopes that they would receive the expert analysis from the Corps' own engineers as to the feasibility of those alternatives, that's the point of NEPA, is a win-win. Those hopes were dashed, and we're here before the court to request that the agency be directed to provide in good faith the discharge of its duty to study, develop, and describe those alternatives.
Okay, Mr. Volker, thank you very much.
Okay, you're very
understand
welcome.
your submission. Thanks to you. Thanks
Sure.
to Ms. Collier. And the court will take the case under advisement. Move to our second argument of this morning. Appeal number 21-2287, Sargent versus Barfield. Herschel, good morning.
Good morning.
Whenever you're ready.
Good morning, Your Honors, and may it please the court. I'm Andrew Herschel, and I represent the appellant Roy Sargent. I'd like to reserve 5 minutes for rebuttal. The question here is whether the Supreme Court's decisions in Carlson and Farmer, under the Supreme Court's decisions in Carlson and Farmer, federal prisoners can bring Eighth Amendment claims based on deliberate indifference to substantial risk of serious harm. Here, that a low-level prison official failed to protect Mr. Sargent from attack by other inmates. And the answer is yes.
Could we start with Ziegler versus Abbasi to get guidance on this question?
Your Honor, I don't think we have to start with Ziegler versus Abbasi because our position is that Ziegler and the cases that followed it changed nothing about the Supreme Court's interpretation of the scope of existing context, and certainly didn't overrule Carlson and Farmer, prior cases having to do with the Eighth Amendment deliberate indifference standard for Bivens claims.
Is
And we
there
think
any
those
indication in that decision that Farmer is included in that Bivens context?
I'm sorry, that Farmer is?
Yeah, is there any indication that in the Ziegler case, that the Farmer case is included in the Bivens context?
Your Honor, it is true that in Ziegler and in Hernandez and Egbert, the court omits Farmer from its lists of Bivens cases when it's talking about them, but I think that actually supports our argument that Farmer is on point here because in Ziegler, Hernandez, and Egbert, the lists specifically identify cases in which the Supreme Court extended Bivens into new contexts and cases in which the Supreme Court suggested extensions of Bivens into new contexts. Of course, our position is that Farmer was neither an extension nor a rejection of an extension. Farmer.
Let me ask you this question.
Yes,
When's the last, we go back to Davis and Carlson, what, 1980 or 81?
Carlson is in 1980, Your Honor.
Okay, 1980, so 43 years ago. In the 43 years, can you identify one time where the U.S. Supreme Court, in a majority opinion, has considered Farmer or discussed Farmer in its Bivens line?
Yes, Your Honor, I can actually.
Malesko?
Yes, sir.
Okay, any other time?
No.
Okay.
So in Malesko, as you were referring to, Your Honor, the court describes the claim before it as a Bivens claim under the Eighth Amendment standard and cites Farmer as having set forth that standard. Of course, the cases that the Supreme Court has been considering over those 43 years have been focused on what constitute new context. And the Supreme Court has exercised caution, of course, when confronted with the concept of extending Bivens into new context. So I think it makes a lot of sense, actually, that Farmer is not coming up in those cases because Farmer was not an extension and an extension wasn't on the table in Farmer. I think that's the conclusion we can draw from the unanimous court's decision to remand what they very obviously understood was a Bivens claim.
When they say Carlson, what they mean is Carlson and Farmer because Farmer subsumed within Carlson.
That's my point, Your Honor, yes.
Yeah.
So considering the scope of Carlson, which I think Farmer tells us a lot about, this case does not arise in a new context at all. It arises in the context that Carlson first established in 1980, and that's the same context that Farmer took place in 1994. And that context is prison officials' deliberate indifference to substantial risks that the inmates who live at their mercy and in their care will suffer serious harm. And that includes, but is not limited to, attack by other inmates, which is what happened to Mr. Sargent in this case.
Isn't that the concern, though, that we're not able to limit the injury? The mechanism of injury in Carlson was medical indifference to an inmate having an asthma attack and not providing what we consider appropriate medical care. And if we expand the language the way that you said just now, that it's not limited to, isn't that the concern that the Supreme Court has asked the courts to caution against?
Well, to be precise, Your Honor, the Supreme Court has cautioned us against extending Bivens into new contexts. And it has explained that we find new contexts where they are meaningfully different from the original cases where the Supreme Court first implied a Bivens remedy. In this case, the appropriate case would be Carlson. And I think everything we know about what constitutes a meaningful difference suggests that the difference between medical treatment and attack by other inmates is not a meaningful difference. I also think that Farmer interprets Carlson that way And Farmer has not been overruled and is regularly cited and is, I think, controls the outcome here. That's also what the Third Circuit held in its 2018 case Bistrian v. Levy, which they reaffirmed in Shorter v. United States in 2021, that Farmer controls our consideration of the scope of the Carlson context and interprets it to extend to attack by other inmates. And that's
Herschel,
exactly...
this question is going to seem nitpicky, but I want to go back to one of the things you just said. You said if there's a material difference.
A meaningful difference.
Meaningful difference, okay. Are you sure that that's the right metric, though? Because to my eye, in Abbasi, the court says, quote, even a modest extension is still an extension.
That's true. The court said that, Your Honor. But the court in Abbasi also very clearly set forth a two-step inquiry in Bivens cases. And the first step of that inquiry, as set forth in Ziegler, is that we must consider whether there are meaningful differences. That's the language they use in Ziegler from the original cases in which the Supreme Court implied a remedy. And that meaningful difference language is quoted again in Hernandez, and it's quoted again in Egbert. So I think the Supreme Court has been very clear that meaningful difference is the standard. Of course, it may be the case that a small, what we might sort of objectively in a non-legal context consider a small difference could be meaningful. In Malesko, the difference that the court found meaningful was the category of defendants. They were suing a private corporation. But that's extremely different from Mr. Sargent's case, which is exactly like Farmer, where a low-level prison official was deliberately indifferent to a substantial risk of which that official was aware, that the plaintiff in this case would be attacked by another inmate. That's very different from Malesko. And I think Farmer clearly signals, and the Third Circuit adopts this reasoning, that the difference between medical care in Carlson and attack by another inmate is not meaningful.
I think that's my concern. How can Farmer tell us whether or not a Bivens remedy is available when it never commented on it in the opinion?
Well, I think there are conclusions to be drawn from Farmer, even though the question that the court is contending with is about the deliberate indifference standard that should be applied in all Eighth Amendment cases, among them Bivens cases.
So can an assumption and an opinion constitute binding law?
I think I would say, Your Honor, that we can infer from the Supreme Court's decision to remand unanimously what they very obviously understood to be a Bivens claim in Farmer. They make multiple references to the fact that a Bivens claim is before them. They could have taken a 1983 case instead to assess the appropriate deliberate indifference standard, but instead they granted cert on a Bivens claim. By that point in 1994, Your Honor, the Supreme Court had already rejected multiple suggested extensions of Bivens. They did it in 1983, they did it in 1988. And yet the unanimous court seemed entirely unconcerned in Farmer with the fact that this Bivens claim didn't involve failures of medical treatment. And I think...
Would you agree that such cases were essentially routine for decades in the district courts and circuit courts?
Yes, I would agree, Your Honor, and I appreciate you...
All of us, to be blunt, all of us recognize the Supreme Court may very well be on the brink of overruling Bivens entirely, or limiting it to cases in which plaintiffs are named Bivens.
I don't want to speak for what the justices are on the brink of doing.
I'm not asking you to. I guess what I'm asking you for is your advice about the extent to which we need to add momentum to that movement.
Your Honor, as I'm sure you all know, the Supreme Court has very clearly said on multiple occasions, in Agostini, in Bossie versus Oklahoma in 2016, that the lower courts should not be in the business of predicting the Supreme Court's future. And that unless the Supreme Court has overruled itself, which it has said it does not do silently, the lower courts are to apply binding law. Of course, they have never overruled Carlson. They have never overruled Farmer. In Egbert last year, they made clear that they say rather than dispense with Bivens altogether, we retain the existing context. Egbert does not overrule Bivens, Davis, or Carlson. So to the extent that the court is inclined to agree with me that Carlson and Farmer establish a context broader than medical care, those cases are binding on this court and control the outcome.
Can I ask you a couple of quick specific questions about this? Mr. Sargent's filings, in your brief picks this up, talk about the difference between active inmates versus programming inmates in the special housing unit.
Yes.
You know what that refers to?
Well, according to Mr. Sargent, Your Honor, active and programming has to do with the extent to which an inmate cooperated with the government in his case. And for Mr. Sargent, that raises concerns about his potential.
What's he?
It's not in the pleadings, Your Honor, and of course, at this stage, we're supposed to take all of his allegations as true and draw inferences in his favor. But my understanding is that, my best understanding is that active inmates did not cooperate and programming inmates did. So programming inmates, of course, are subject to a severe threat of violence by active inmates.
And my other question is, in essence, most of our discussion here has been pretty abstract, and we don't, at least I don't see very many specific allegations about inmate-on-inmate violence against Mr. Sargent himself, other than having just this general statement, having to battle with inmates about my stay in prison, leading to argument and some fights. Is there anything more specific that I've missed?
In the complaint, Your Honor, if you continue reading in that same paragraph, in the final sentence on that page, he says that he was attacked while in handcuffs by one of the inmates with whom he was assigned to live. Besides that, Your Honor, no, you have not missed anything.
So we're dealing with it, again, that kind of general level of pleadings at this stage.
That's right, Your Honor. But our position is that drawing all inferences in Mr. Sargent's favor and taking these allegations as true, they easily satisfy the standard for deliberate indifference claim. Yes.
And he connects it, right? He connects it to the defendant as the one that's exposed him to this particular situation for filing the grievance or the complaint.
Yes, yes.
He's been placed in that circumstance by the defendant.
Not only that the defendant was aware of this risk, but that the risk was the motivating reason for the housing assignment. Yes, Your Honor. I see that.
Want to save some time?
Yes, please.
Okay, very well.
Thank you.
Good morning, Sponge.
May it please the court, counsel. I'd like to touch briefly on the waiver issue to start with. In a nod to Cesal, it is true that there would be no waiver if the district court failed to recognize an Eighth Amendment claim, and that is not the case here. Appellant's complaint and pleadings do not plausibly allege an Eighth Amendment failure to protect claim. Just like in this court found in Owens v. Baldwin, to the extent there is, as Judge Hamilton recognized, a very brief comment in the complaint, this 7-page complaint talks about the context of that all in a retaliation complaint. And if we look at the grievance documents attached to the complaint, there is no mention of the Eighth Amendment complaint in the grievance documents.
Is it your position, though, that he has to mention the Eighth Amendment expressly?
No, it is not, but it needs to be plausibly alleged. There needs to be some context associated to those complaints. And frankly, there was no context given here, and that's why the district court did not mention an Eighth Amendment complaint.
The allegations in the complaint is that Barfield placed him with cellmates who she knew would attack him. Those are the allegations in the complaint.
The allegations are very broad.
If we construe that
sorry,
liberally, it's fine. If we construe that liberally, why would that not raise as far as an Eighth Amendment claim?
There needs to be a bit more to the context there.
It's a pro se complaint. I mean, let's not waste time on waiver here, okay?
I understand.
Okay.
The issue, however, wasn't raised by his appointed counsel, and the issue wasn't raised in the
district.
I'm sorry?
Wasn't raised by his appointed counsel in the district.
In district court, yes.
It's following the instructions of Judge Durkin. Let's hear, if you want to make a record about waiver, go ahead.
Okay, thank you. We can move on to the substantive argument, Your Honor. This case does present in a new context. Carlson involved, as Judge Pryor pointed out, Carlson involved in inmates' complaints of deliberate indifference to an inmate's health through the failure to provide medical care. This case involves cell assignment and prison housing, which is quite a bit different. Carlson involved doctors and nurses making specific recommendations and treatment recommendations to or about a very specific inmate, giving discrete medical advice that could be followed or not followed, as the case was. Here, cell assignments...
Mr. Sargent, though, directs his attention and says it's not about a housing decision, but it's more about indifference to the risk of violence.
As they phrase it, it's really about a failure to protect. And even if we termed it as a failure to protect or a failure to recognize a risk of violence, that is different than the Carlson claim. And so the Bozzi court said that sometimes we can have even a complaint that talks about the same right at issue, the Eighth Amendment, and we can also have a complaint that talks about the same, perhaps similar mechanism of injury, but they can present in a different context still. And so that is the case here. Inmate movement considers inmate behavior, inmate medical conditions, mental health conditions, prison staffing, prison space.
There's some differences. Let me ask you, Ms. Munch, how your position would apply to a case in which 3 guards got together and just beat up a prisoner for no reason. Would that be a new context?
That would be a new context, Your Honor.
So not actionable at all?
There would be a Federal Tort Claims Act available. There would be...
Against the government, but not against the individual.
That's correct, Your Honor. There would be, if we looked at the special factors that counsel hesitation, we can talk about the Federal Tort Claims Act, the remedial measures available. So the Federal Tort Claims Act, the Administrative Remedies Program.
Would you defend the Federal Tort Claims Act, the hypothetical claim we're talking about here, on discretionary function grounds?
I don't know, Your Honor.
I wouldn't be confident as a plaintiff's lawyer that you would not. Could you address our decision in Heron, which looks an awful lot like this, and which came after the Malesko opinion identified the concept of contexts for expanding Bivens?
What I would say to the...
treat it as overruled.
So what I would say to the court is that the court did not have the benefit of the Supreme Court's decision in Egbert, and so did not have the benefit of conducting that 2-step analysis that is required and to be decided. Abazi has also told us that has made clear that we can no longer rely on our own prior precedent to recognize a Bivens remedy. We must look specifically at Bivens, Davis, and Carlson and do that 2-step analysis. And so the prior decisions would not be precedential here.
So you think we have been overruled by the Supreme Court?
The ancien regime is no longer, so yes.
Ms. Bunch, let me ask you this question. In Egbert, the court, as you know, in a couple of different places, seems to suggest that the 2 steps, recognized in Abbasi, really collapse down into one question. And the way the court phrases that question in a couple of places is whether there is any rational reason, even one, to think that Congress is better suited to weigh the costs and benefits of allowing a damage action to proceed. What's the hypothetical where that question would ever be answered in a plaintiff's favor?
In an Eighth Amendment context, it would be the Carlson case.
Well, sure, because until Carlson's overruled, right?
Correct.
But can you think of any other scenario where that question could ever be answered in a Bivens plaintiff's favor? Just making one up.
I cannot think of one right now. Even
If that's right, what that has to mean, correct, is a legal matter, just necessarily so, is that any extension of Bivens, unless you have factual identity, the point Judge Hamilton was making earlier, is an empty set as a legal matter. It is truly an empty set, because there's no way you could answer that question that the court in Egbert sets forth twice in a plaintiff's favor. It's impossible.
I can't envision a circumstance right now, but I suppose there is always a possibility.
I'll just make an editorial comment that I have never seen opinions from the Supreme Court claiming such levels of judicial modesty and incompetence as in Abbasi, Hernandez, and especially Egbert. Would you agree with me, Ms. Munch, that under Section 1983, virtually all of the major policy decisions have been made by the Supreme Court with respect to what the statute of limitations will be, whether there are defenses of qualified or absolute immunity and to whom they apply when, what kinds of damages are available, when punitive damages. In all of those instances, the court has felt competent to make those decisions subject to potential congressional override.
That may be the case, Your Honor, but what we have here is the Prison Litigation Reform Act, and what we have here is Egbert and the direction of
Nobody's talking about refusing to apply the Prison Litigation Reform Act on constitutional grounds.
We have the direction from the Supreme Court telling us that our analysis is limited.
Let me try a little different angle. In your brief, you described the Third Circuit's decision in Bistrian as an outlier. In what sense do you think it's an outlier? I didn't see any other circuits that have disagreed with it until the Fourth Circuit's recent case.
It's an outlier because it did not take into consideration the Egbert analysis. It did not have available to it the Egbert analysis. It also relied on Farmer, and both of them sort of presumed really that Bivens was, the cases were Bivens cases. And so again, if we go back to the very direct language of the Supreme Court in Egbert, even Hernandez, which came after Bistrian and Farmer, we have to conduct this two-step analysis and try to determine whether there's a meaningful difference in the context of these cases. In this case, in the appellant's case, is meaningfully different from Carlson.
If the plaintiff had made these same allegations in a state prison context against a state prison counterpart, do you agree that that would state a claim under the Eighth Amendment?
I don't know.
If there's any question about it.
I don't think so.
No, I mean, do you understand the question? The question is under 1983, if Sergeant's a state inmate, absolutely. There's no question about that.
It may. I think the Supreme Court in Bell v. Wolfish recognized rather elaborately the complexities that the prison officials face in the day-to-day management of prisons, and the difficulties that are presented here. If we're looking for a case to rise to the top and to suggest to the Supreme Court that this is an Eighth Amendment claim, this would probably not be the case that would do that. Mr. Sargent did not raise the issue in his grievances. He did not exhaust his administrative remedies. And so that is one thing that needs to be done.
Theory that he has to exhaust theories in the grievance process, that he has to identify a particular amendment?
He does not. He should at least have a discussion in his grievance documents of that issue.
Where does that come from? Where is that?
The Congress has given to
You're just talking about 1997 exhaustion requirement?
yes.
Nothing more That just says exhaust available administrative remedies. It doesn't say, it doesn't involve pleading requirements in grievances, does it?
No, we're not talking about, but he doesn't raise the issue of the cell assignments at all in his grievance documents. So if we're looking at the availability of alternative manners in which to raise his claim, he has not done so in his grievance.
Is that part of your defense? Yeah, but there was a bunch of them that were out. In the district court?
It did not come up. So it wasn't raised by any counsel. The Eighth Amendment wasn't raised by any counsel until well after the docketing statement, until well after the motion to stay pending the Egbert decision. So once the Egbert decision came out and foreclosed the First Amendment claim, only then was the Eighth Amendment claim raised.
If we agree with the connotation that Carlson context, we're limited to the Carlson context. Let's say that those facts arise again today, all right? Would it be proper for the court to take that up, seeing that the prisoners have what you've identified as alternative remedies? Under the Prison Litigation Reform Act, I mean, is this the suggestion that if the Carlson context arose again, Bivens would, under those last two steps, would foreclose the court being able to hear them?
Well, in the two-step analysis, there has to be a new context to come to the special factors. So if the court were to decide that there was not a new context, then I suspect that we wouldn't get to the special factors analysis.
In Carlson, the prisoner suffered an asthma attack, right?
Yes, a very severe asthma attack, yes.
And it was fatal.
Yes.
So the prisoner is suffering a heart attack. Different context?
Not necessarily. If in Carlson, I think if we looked at the context of that medical event, we're looking at physicians that were involved, who made specific medical recommendations on treatment. And I think there were medical equipment that was not available, that were recommended to be available, or that they were not working.
Because all that's true with respect to a heart attack, or maybe a infection.
That may be a Carlson case.
Thank you.
You're welcome. If I can conclude?
Sure, yeah.
For the reasons stated, we simply ask the court to affirm the district court's dismissal. Thank you.
Okay, very well. Thank you, Ms. Mudge. Mr. Herschel, you have a few minutes left here.
Thank you, Your Honors. I'd like to make just 3 points. The first and most important, Your Honor, Judge Hamilton, you mentioned the court's decision in Herron. Herron is extremely similar to this case. It's a Bivens claim by a federal prisoner who suffered attack, or actually in Herron, it was an attack, but the prison official was deliberately indifferent to a substantial risk that the prisoner would be seriously harmed. So it's deliberate indifference to prisoner safety. That's from 2016. As Your Honors mentioned, that's with the benefit of the description of the Supreme Court's caution towards new context in Malesko, and that is binding precedent in this circuit.
Did the court make a determination in Herron that this was appropriately brought under a Bivens claim, or was that issue not raised?
Your Honor, in Herron, that claim survived to summary judgment, and the question had to do with the
question a different way.
Sure.
Was there an assumption that there was a appropriate Bivens claim in Herron?
That appears to be the case, Your Honor. Yes. And that's also true in this court's decision in Dale in 2008, and that's also true in this court's decision in Bagola in 1997, and that was also true just last year in this court's decision in Gooch v. Young. So I think in this circuit, it's very clear that we do not view the difference between medical care and non-medical care claims as meaningfully different. I also think it's worth pointing out perhaps that in Carlson itself, the medical care aspect of the allegations was confined to a footnote. So it doesn't seem that the Supreme Court was particularly concerned with that aspect of Carlson. The Supreme Court described it only as a violation of the Eighth Amendment's prescription against infliction of cruel and unusual punishment. Of course, also in 1991 in Wilson v. Sider, the Supreme Court itself said, quote, "We see no significant distinction between claims of inadequate medical treatment and other conditions of confinement claims, which includes failure to protect inmates from threat of attack by other inmates."
I think the challenge you have, Mr. There's no question. You'd much rather be briefing this case in 1990 than you would 2023. There's no doubt about it. It's the more recent precedent. It's Hernandez, Ziegler, Egbert, right? That makes it very difficult for Mr. Sargent.
I disagree respectfully, Your Honor, that I agree with the proposition that we would have been better off in 1990. Yes, of course.
The question would not even have arisen.
That's true. But I think it's important to observe that in Ziegler, Hernandez, and Egbert, the court retains the two-step inquiry. The court retains the meaningful differences standard. And Justice Thomas's description.
Yeah, go. I'm sorry, finish your thought.
Justice Thomas's description that this two-step inquiry often resolves to a single question, I think implies that it does not always resolve to a single question.
Fair enough. That question is extremely hard for a plaintiff to answer in her or his favor.
I don't disagree, Your Honor. But just to conclude, Carlson and Farmer have not been overruled and are binding on this circuit as to the scope of the Carlson context. Herondale, Bagola, and Gooch, which is just last year, I think reaffirmed that that's the position in this circuit, that claims like this are entitled to a Bivens remedy.
What's the case from last year?
It's Gooch v. Young, Your Honor. It's cited in our opening brief. It has to do principally with failure to exhaust questions. Thank you very much.
Okay. Very well. Mr. Herschel, one final question. Did your firm take this on as a pro bono matter?
We did, yes.
Yeah, the court very much appreciates your service, the service of your law firm, and that of your colleagues here. Ms. Munch, thanks to you as well. The court will take the appeal under advisement.
Thank you, Your Honor. It's a pleasure.
Okay, we'll move to our third argument of this morning, after which we'll take a brief recess. The third case is number 22-2077, Mestek versus Le Coeur d'Oreille Community Health Center.
Good morning, Your Honors.
Just pause 1 second, Mr. Harrison.
Yes, sir.
Like a tennis match. We'll wait for the crowd to...
Okay, Mr. Harrison, good morning.
Good morning. Nick Harrison for Appellant Mestek. I apologize, Your Honors, for my hearing disability today, and I hope it doesn't affect my voice. So Ms. Mestek sought a judicial remedy for an injustice done to her by the managers at a clinic associated with a tribal government, the Le Coeur d'Oreille tribe. She sought relief for False Claims Act, whistleblower retaliation, blacklisting, and interference with business. Her claims were dismissed by the district court entirely. The federal claims were dismissed on a sovereign immunity defense, tribal sovereign immunity. And the state claim was dismissed for lack of, in the discretion of the court, supplemental jurisdiction, given that the federal claims were dismissed. The difficulty with the district court's decision in dismissing the federal claims was the way the district court found the facts that were necessary to the determination of tribal sovereign immunity. In this circuit, as I'm sure Your Honors are well acquainted, tribal sovereign immunity is not a jurisdictional question. So the only vehicle for finding disputed facts is the federal rules of civil procedure that we're all familiar with, which includes a method for determining a motion to dismiss where the facts are taken as true in the complaint, a motion for summary judgment where there's a chance for discovery and competing evidence before those facts are determined. If this were a jurisdictional question, there could be a less formal fact-finding procedure, a jurisdictional discovery procedure, but that's not how facts can be found in the Seventh Circuit on a sovereign immunity defense.
Before you get into the arm of the tribe test, can I ask you, do you have the statutory language in front of you?
For which statute, Your Honor?
In the False Claims Act, the Anti-Retaliation.
I have it. I'm very familiar with it.
Okay. Walk me with that text, with that statutory language in mind, as a matter of statutory text. Walk me through the abrogation analysis.
Understood. So the former version of the statute, before it was amended, had the word employer in the whistleblower prohibition. In other words, no employer shall retaliate.
Right. So no, focus on it as it exists today.
And as it
exists today in the United States Code.
As it exists today, it no longer has the word employer. It never had the word person. And because of that, the initial argument made by the defendants below, which the district court actually did not adopt, was that that statute didn't apply to tribes because the tribes were not a person. And because of the amendments and the language in this provision, as distinguished from the Keaton provision of that same statute, that argument didn't prevail. So the question is, even though that section doesn't mention tribes, which is, I assume, the key issue here, but it does essentially have a very broad universal application. It applies to not only employers and persons, but basically everyone. The question is, does that abrogate tribal sovereign immunity? Now, appellant took the position that it does, and we relied on a First Circuit case, which I mistakenly cited, and I apologize, as a DC Circuit case in my brief, Henry Coughlin. And that case essentially said, and the Seventh Circuit has a similar case, and I'm not sure that case name will come to me in a moment, which says magic language is not required to abrogate immunity. What is important is that the congressional intent is clear.
Right. In absent that, I think that's fair enough at that level, but absent any term, Indian, Native American tribe, you have nothing like that. And so I think the only argument you have is one that a conclusion that would indirectly follow from the language. But I don't even know that you have that, because you don't have broad use of terms like, any government.
I understand Your Honor's point. And, the appellant's analysis is based on this case law that says, one, no magic language is required. If the intent seems to be universal, like in the Henry Coughlin case, the bankruptcy case, where all governments were embraced in the language, this statute, I think, is even broader than that, because it isn't even limited to governments. It isn't limited to anything. It's simply limited to anyone who retaliates, any entity that retaliates.
But that doesn't do it, because isn't the inquiry that you have to look at the language of the statute and be able to discern from it congressional intent to abrogate tribal sovereign immunity, and silence, through the breadth of language is not enough.
Well, I think Henry Coughlin is to the contrary, and I think the case which will probably escape me is to the contrary in the Seventh Circuit about the not having any magic language required. If that case comes to me, I'll mention it.
But do you agree that the Supreme Court has said repeatedly that abrogations of tribal immunity need to be unequivocal?
And Your Honor, I'm having if I had just a moment with
I need to repeat it, I'm happy to.
If you wouldn't mind.
The Supreme Court has said repeatedly, magic language aside, no specific formula, but that any abrogation of tribal sovereignty, tribal sovereign immunity, needs to be, quote, unequivocal.
I agree with that. Now, the key here, Your Honor, assuming that the tribe's immunity was not abrogated, that's not the end of the story in this case. And the reason is that the complaint alleges claims against individual defendants and does not allege a claim against the tribe. The tribe is not a defendant here, and there's a reason for that. If you read the tribal chairman is named, by the way, but it wasn't intended for the tribal chairman to be named as the tribe. So the reason for that is Ms. Mestek wasn't the only victim of the alleged pattern of illegal conduct here. The tribe was a victim too. As the complaint alleges the facts, the tribe did not approve the illegal submission of false claims that Ms. Mestek blew the whistle on, nor did it approve her termination.
Were we permitted? Were we permitted to take a look at the tribal code of law
Yes,
that extended it to LCO and CHC?
no problem with taking a look at the tribal law. Tribal law is capable of being judicially noticed. The problem with the district court's decision here was what it did with that tribal law after it judicially noticed it. Because just because you can judicially notice a document doesn't mean you can draw any fact inference from it you wish. The document has to establish the fact that is to be relied upon for the decision.
I think we're headed to talking about STAR, but before we do that,
We are.
can we just back up just a moment with me?
Yes, Your Honor.
When we're taking a look at the tribal code, now we can take a look at that. For the individual defendants, if we set Pope and STAR aside, would that immunity not stretch to cover the other defendants?
Good question, Your Honor. I would say under one theory of the facts that is actually alleged in the amended complaint, the answer would be no. And that's because the complaint alleges, I think it's in the first several pages, 4 to 6, that the center, the health center, as it was being operated, not as it was intended in the tribal code, but as it was being operated, was essentially a rogue operation of folks committing violations of federal law that the tribal government never approved and never intended. If those facts are taken as true, and it's appellant's view that there's no choice on a motion to dismiss but to take those facts as true, then none of those defendants have immunity because the health center doesn't have immunity. The tribe does. Because the health center, getting to the arm of the tribe question, isn't actually functioning as an arm of the tribe. It may have been intended to be, but if it isn't de facto functioning that way, it doesn't get the benefit of the tribal immunity. It's analogous to, if I may go to STAR just for a second, to Medical Director Starr acting ultra virus in terminating Ms. Mestek in retaliation in violation of federal law. His boss didn't approve that. Ms. Bay, she admitted that to Ms. Mestek, that's in the complaint. She was the liaison between STAR and the governing board. There is no evidence here, and evidence really isn't at play yet, or shouldn't be at play in this case, because, we're just dealing with the facts in the complaint on a motion to dismiss. But those facts show that STAR acted ultra virus. Bay didn't know about his action, didn't approve it. She was the go-between with the tribal board. So here, until there's some facts that are established, and they cannot be done by simply judicially noticing what the tribal governing board intended.
Harrison,
Yes, Your Honor.
If I could interrupt for
Please.
on this, I'm baffled by your focus on this question of who signed the termination letter.
Okay.
Is there any doubt that Ms. Mestek was fired?
No doubt that she was fired in effect.
She has been terminated from her employment. That's the foundation.
She hasn't been allowed to return to work. She's applied several times.
She has been terminated from her employment, correct?
Yes, but not by the tribal governing board to my knowledge.
I understand, but you keep saying this was ultra virus.
I do.
Ultra virus acts, let's say by a corporate officer or by a government official, can be ratified, correct?
They can be. There's no facts in this case to say they were.
Well, she was fired.
Agreed.
Nobody has rehired her. And
Definitely true.
Ordinarily, this kind of internal disagreement that you think should have been raised as to who got to write the letter, who got to make the decision, doesn't really create rights in people outside that governing.
I'm not sure I follow your honor's reasoning. If
Well, let me ask it this way: would immunity apply in this case, in your view, if Ms. Bay had signed the termination letter?
not if she had done it in retaliation without the board's approval.
Well, that's a merits question. You think she had to have the board's approval?
Well,
Opposed to
yes,
just
I don't think.
exercising her authority as a director.
Well, she wouldn't have been doing that if she had been acting in violation of federal law to retaliate.
It's like an ex parte Young theory, right? The legal fiction that you're not exercising governmental authority if you're violating the law.
I wouldn't say that, Your Honor.
Okay.
But I mean, what we're talking about here, I think, are facts and not law at this stage of the case. And the error of the district court was how it determined these facts. If Ms. Bay had hypothetically made the decision to terminate Ms. Mestek, but for the very same illegal reason, to basically cover up a pattern of illegal conduct, to sort of shoot the messenger, if you will, in the whistleblower terminology, and the board was unaware, didn't approve the illegal conduct or the retaliation, that's an ultra-virus act. Her job description doesn't let her do that.
I don't know that ultra-virus helps us all that much, but honestly, the way I see this is she's coming in, she has been terminated. There doesn't seem any question about that. She's been terminated, and she sued both the community health organization. Okay, but she's also sued all of these individuals in their individual and official capacity.
Correct.
But all of the relief that she's looking for is it's all employment related.
That is incorrect, Your Honor.
Reinstatement, back pay, lost benefits, no future retaliation.
The injunctive.
I understand why Your Honor says that. The district court said that, and that was an error of the district court. And the reason is, although some of the relief she seeks would fit Your Honor's description, she does seek, for example, a relief against future blacklisting. That blacklisting can be implemented by individuals without approval of the tribe, without using their authority as a tribal official. They can just call up someone at another employer and say, don't hire this person.
Mr. Harrison, can you point us to where in the district court you made that point?
Made which?
The point that you wanted injunctive relief that would run against individuals, not in their personal.
Well, in our opposition to the motion to dismiss, we did, and by the way, our injunctive relief claims are pretty clearly stated in the amended complaint, but we also argued in the opposition to the motion to dismiss that we were seeking injunctive relief and that there were fact issues.
I'm looking at page 11 of that document.
Of the opposition?
Yes. And what I don't see is an argument that individual injunctive relief in personal capacity needs to be considered separate.
I understand, Your Honor. My time has expired. Shall I answer that
Please.
question? So the best I can tell, Your Honor, is that the way we worded it at that time in that opposition was we were trying to inform the court this was not a motion to dismiss question. It was a summary judgment question, and that there were fact issues related to both injunctive relief and damages for each of the defendants as to whether sovereign immunity would apply, and we needed to be given the benefit of the proper fact-finding procedure to determine those. That's the best I can tell you. But, Your Honor, there is one point of law that responds to your question, if I might. I'll be brief. The Supreme Court has made clear that if an issue, let's assume for the purpose of argument, Your Honor is reading our opposition to not raise the question of injunctive relief clearly, or immunity related to injunctive relief. Let's say it wasn't raised below. The Supreme Court has said clearly that if there is an issue not raised below, but if it's a matter of well-settled law, and if there would be an injustice by not hearing it, Your Honors would have the ability to hear and decide that question. And I believe that would be the appropriate course here. Thank you.
Okay. Thank you, Harrison. Mr. Adams, good morning.
Good morning. May it please the court, I'm Andrew Adams, and I'm here representing the defendants' appealees in this matter. While numerous issues have been raised on appeal, this case presents a question of whether the district court correctly applied Rule 12b-6 in determining that Mestek failed to state a claim upon which relief can be granted due to the sovereign immunity afforded by the Community Health Center, the clinic owned and operated by the Lakota Band of Lake Superior Chippewa Indians. This district court's answer was correct, and we respectfully ask this court to affirm that decision. With my time, I'd like to discuss 2 points. First, I'd like to explain why the district court correctly applied, or concluded that the tribal defendants are immune to Mestek's suit. And second, I'd like to explain why the district court's application of Rule 12b-6 is correct. Turning to my first...
Adams, before you begin, would you agree that the complaint is sufficient but for the tribal immunity defense? It states a claim for retaliation in violation of false claim.
Your Honor, I would agree that it states that, but I would disagree that Mestek can sustain, irregardless of the immunity, she cannot sustain the claims against the individual tribal defendants because the False Claims Act under Mestek cites to 31 USC 3729 sub A1, which is the Ketam provision, that can't be brought against individuals.
That's not the Ketam provision. That is the substantive prohibition on defrauding the United States. She's suing under 3730H, correct?
She brings up both statute.
Well, she says that 3729A was violated, right?
Correct.
But that's not my. She doesn't have to prove that it was actually violated to make her retaliation.
I would agree with that, Your Honor.
Okay. So I'm not trying to quibble with you about this. I just want to make sure that we're in agreement that the focus has to be on the question of tribal sovereignty.
Yes, the question is directly focused on immunity. Turning to my first point, the tribal defendants argued and the district court concluded that they are entitled to sovereign immunity. The district court began with the general proposition that Indian tribes are sovereigns that possess sovereign immunity from suit, and such immunity can only be abrogated by Congress if Congress unequivocally expresses that purpose. Relying on Del Muth v. Muth and Slack v. Washington Metropolitan Area Transit, the district court correctly observed that, quote, no evidence that Congress intended to remove sovereign immunity to a tribal arm under the False Claims Act's anti-retaliation provision. Therefore, a simple ambiguity in language is insufficient to hold the tribe or its arm liable. At page 7, that ruling is consistent with Supreme Court precedent and this court's decision in Myers v. Oneida Tribe. Specific to the question of whether the clinic is an arm of the Lakota Band of Lake Superior Chippewa Indians, the district court applied the Ninth Circuit's modified test or version of a test first established by the 10th Circuit and Breakthrough Management Group. The district court concluded that 4 of 5 factors weighed in favor of concluding that the clinic is an arm of the tribe. 1, the method of its creation. 2, its purpose. 3, its management structure. And 4, the tribe's intent to extend its sovereign immunity to its clinic. While the district court found that the financial ties between the tribe and its clinic ambiguous, it is clear from Title 14 of the tribe's laws, which is the Community Health Center's personnel policies and procedures, and the complaint by Mestek, that they do not operate in isolation from one another. And although the district court did not address the 6th factor from Breakthrough, that is whether extending tribal sovereign immunity to the entity serves the purpose of immunity, the tribe's clinic provides health care to tribal members living on or near the Lakota Indian Reservation in northern Wisconsin And this service is one of the most important services offered by the tribe to its tribal members. The district court concluded that the documents confirm a deep, long-term relationship between the community health center and the tribe at pages 11 and 12. Therefore, extending the tribe's sovereign immunity to its clinic, a tribally owned entity, is consistent with the purpose of sovereign immunity. Mestek asked the court to conclude that there is a dispute about whether the tribe's clinic operated consistent with tribal law when she was terminated. But she does not argue that the matters discussed under tribal law are incorrect or present an alternative test to be applied by the district court. Moreover, she alleged that certain correspondence about operations of the tribe's clinic were forwarded to the tribal governing board. The only reasonable inference from that allegation, coupled with the tribe's own law, is that the tribal governing board has oversight authority for the clinic. Even Mestek's effort to obtain relief against Taylor in his official capacity as the tribal chairman evidences this oversight authority by the tribal governing board.
What's your response to the point that Mr. Harrison was making on the alleged ultra vires conduct? That in other words, I heard him saying that is it Dr. Shannon Starr?
Yes.
That Dr. Starr, exceeded authority, in terminating the plaintiff that way, and that somehow cuts against an application of tribal sovereign immunity when somebody acts ultra vires like that. It wasn't within Dr. Starr's authority to terminate employment, and therefore it's not an act that would in any way be eligible, for the protection of tribal sovereign immunity. That's the substance of the position.
Yeah, yes, Your Honor. I would agree to that summary of Mestek's points.
What's your response to it?
My response to it, the first response is that I'm in agreement with Judge Hamilton that acts by individuals on an organizational chart that are lower than supervisors can be ratified. And that occurred here. And concerning ultra vires and the arguments that Mestek is making, the only way that the ultra vires acts stick to the wall, Your Honor, is if if these individuals are violating tribal law. Mestek has not shown in any respect that they have violated the tribe's own laws. And Your Honor, I would also argue that they were waived by Mestek. They were not properly preserved for appeal. Judge Conley, in his decision, says unequivocally that Mestek left the last word concerning individual official tribal immunity to the defendants. And with respect to the individual tribal defendants, Your Honor, the district court, relying on Lewis v. Clark, explained that aside from, quote, unspecified damages, Mestek is seeking relief that would have to come from the community health center, putting the burden of any judgment on the tribe's health center at page 13. Therefore, it concluded that, quote, Mestek may have formalistically sued Taylor, Bay, Starr, Cleakin, and France in both their individual and official capacities, but her claims and requested relief that the real party in interest is the community health center, an arm of the tribe, at 14. Furthermore, this court observed that the anti-retaliation provision of the False Claims Act can only be brought against an employer, not its employees. Thus, any claim under that provision would have to be against the tribe's clinic, bolstering the district court's conclusion. Just as importantly, and really a threshold matter, the district court noted that Mestek, quote, makes no argument on the matter of sovereign immunity for the individual employees and giving defendants the sole word on the issue at page 14. Mestek acknowledged the same in her principal brief, yet despite this court's clear rule that a party bears the burden to, quote, demonstrate that the arguments below adequately develop the legal basis for a claim, and that the court erred in holding otherwise, end quote. That's from Krebs v. Gravely from 2021. Mestek's principal brief relied almost exclusively on her complaint not her response to the motion to dismiss. Only on reply before this court did she identify a singular paragraph where she mentions in passing a distinction between damages and injunctive relief and ultra-virus acts. But these conclusory, disarranged remarks are exactly the type of underdeveloped issues that this court should refuse to address. Thus, this court should not address Mestek's waived and forfeited arguments regarding sovereign immunity of the individual tribal defendants. Turning to my second point, the defendants moved under 12b-6, and the district court correctly applied that rule. Mestek argues that the district court applied the wrong standard for two primary reasons. First, she argues that the district court reviewed matters outside of the pleadings and therefore should have converted the motion to dismiss to one of summary judgment.
Mr. Adams, Mestek is alleging that Starr acted outside the scope of her employment when she fired or terminated Ms. Mestek without the health director's approval. Isn't that enough for an individual capacity claim, at least against Starr?
I would disagree, Your Honor. At page 10 of Judge Conley's decision, he states that under paragraph 4, while plaintiff argues that Bay simply served as a, quote, figurehead capacity, Bay personally signed her termination letter. In fact,
that's not the facts in the complaint, right? Wasn't it Starr that signed the termination letter?
Yes, but I believe the point that Judge Conley was making was that at the end of the day, it didn't matter, Your Honor. His footnote at the bottom of page 11 states plaintiff also claims that Starr was actually the one who fired her. But even if this were true, Starr was required by the tribal code to report to the health director, Bay, on all matters regarding patient care and the supervision of medical personnel. At the end of the day, Your Honor, the ultra-virus arguments are but a distraction where Mestek is trying to grasp onto some jurisdictional basis by which either the district court or this court could review the claims. The claims are forestalled because of the sovereign immunity of the Lakota Band of Lake Superior Chippewa Indians that naturally attaches to their clinic that services their tribal members on their treaty-bounded Indian reservation. And it also protects the individual tribal defendants in their official capacity.
So in essence, even if Starr had signed that termination letter, they still had to, as the health director reporting to the tribe governing board, had to approve that decision.
Yes, Your Honor. And again, to Judge Hamilton's point, we would argue that that was a ratification under tribal law that is totally permissible, and it pulls the rug out from underneath any accusations of ultra-virus acts.
Mr. Adams, the thing that concerns me is that is the Supreme Court's decision in Lewis against Clark, which seems to leave room for individual damages claims against individual defendants who are members of a tribe. And the court says, in essence, the fact that an employee of a tribe was acting within the scope of his employment at the time he committed a tort is not on its own sufficient to bar a suit against that employee on the basis of tribal sovereign immunity. That suggests to me that individual damages claims are not barred by tribal sovereign immunity, but where we need to go, or where you need to go on behalf of defendants on individual damages claims, is that they're not properly suable under the retaliation claim of the False Claims Act. Several circuits have said no individual damages claims as a matter of False Claims Act law. Do you agree with that?
I do agree with that, Your Honor, that False Claims Act claims, anti-retaliation claims, can only be brought against the employer.
Well, I'm not sure about that with respect to injunctions, but we'll see. Certainly damages have been allowed only against the employer.
So For all the reasons I provided and those in our brief, we respectfully ask this court to affirm the district court's decision dismissing Mestek's claims. Thank you.
Thank you.
Adams, thanks to you. Mr. Harrison, your time had expired, but I'll give you 1 minute.
Your Honor, the key here is what facts have been established and what facts are yet to be established, and how do the federal rules allow them to be established in this circuit when sovereign immunity is not jurisdictional. This arm of the tribe 5-part test, some of those parts were addressed in fact allegations in the amended complaint explicitly. Those facts have to control until the fact-finding process is used, the correct fact-finding process. The same is true for...
How would that reasoning apply, Mr. Harrison, if, let's say, a state police agency is allegedly operating outside the law as a rogue operation? Would that defeat state sovereign immunity against that state agency?
If the facts were alleged that the operation was rogue, not sanctioned by the state, I think there would be an ultra-virus exception to sovereign immunity.
What case recognizes that?
Well,
that would be an extraordinary innovation under Section 1983.
I cited the Malone case in the footnote in the opposition to the motion to dismiss, and a couple of other cases in that opposition. The names will escape me in the moment, about ultra-virus acts being an established exception to sovereign immunity. It's a well-established rule, Your Honor.
Okay.
The key, though, for this case is the facts in your hypothetical of the state police. Those facts of the rogue operation would have to be established, and if it were in the Seventh Circuit, they would have to be established by either the allegations in the complaint or by the normal discovery and summary judgment procedure. There is no other room for that fact-finding. Thank you, Your Honors, for the time.
Quite welcome, Mr. Harrison. Mr. Adams, thanks to you. We'll take the case under advisement, and the court will stand in recess for 10 minutes. We'll continue with our fourth case of the morning, appeal number 21-2416, Ray Crowell versus Mark Sevier. Bannon, good morning.
Good morning, Your Honors. May it please the court, Patrick Bannon on behalf of petitioner appellant Ray Crowell Jr. I believe I requested 3 minutes for rebuttal, if that's agreeable. Thank you, Your Honors. It is undisputed that Mr. Crowell's counsel performed efficiently in failing to notify him that one of the 3 charges to which he pled guilty, and nearly half of the 13 charges against him, were time barred. This was prejudicial because if Crowell had been properly advised, he would have gone to trial instead of pleading guilty to the time barred charge. The state courts applied the Supreme Court decisions in Strickland unreasonably when they denied his PCR petition, and this court should reverse. The Supreme Court requires that a defendant show a reasonable probability that he would have gone to trial, and Mr. Crowell has made such a showing. In his prior to accepting his plea deal, just a few days before trial, he told the court that he was not pleading, and he only accepted his plea deal after his motion to terminate.
Is there a way for us to kind of move forward and just look at that second step? What prejudice?
Absolutely. So the prejudice here was that if Mr. Crowell had been properly advised of the time barred charges, that he would have gone to trial and he would not have pled guilty to a time barred charge against him. It was the reason he filed his initial pro se PCR petition, and it's been his request for relief in each of his subsequent submissions, both in his appeal to the...
It's clear, right? That saying that I would have gone to trial anyway, that's not...
Yes, he has to show a reasonable probability that he would have gone to trial. And I think in
Mr.
this...
Bannon, focusing on Judge Pryor's question, and I'm picking up you make this statement a few different times in your brief. You're very clear about it, that regardless of his chance of acquittal and potential sentence he may face, Crowell insisted he would have gone to trial. I'm looking at your reply brief.
Yes.
On what rationale? Just articulate the rationale. It is a subjective inquiry, right? The record
Yes.
doesn't tell us, but what could conceivably be the rationale of a choice to go to trial?
So Mr. Crowell always intended to go to trial on these charges, even prior to knowing that the time bar charges, the issue of the time bar charges, and his decision to plead guilty was not based on the fact that he did not want to go to trial initially, but the fact that his trial counsel, his motion to terminate his trial counsel was not granted by the court. And as he stated, he feared going to trial with his trial counsel. He explained in his PCR petition and in his other filings that he did not believe that his trial counsel was preparing an adequate defense. And he also believed that his trial counsel had been lying to him about who was prepared to testify on behalf of the prosecution. And he believed his trial counsel was doing that because in order to induce him into taking the plea deal. And he feared going to trial on those charges. He filed his PCR petition for post-conviction relief, seeking to go to trial on those charges after he was made aware of the fact that the time-barred charges, that 6 of the 13 charges were time-barred, and that one of the charges in his plea deal was time-barred as well.
Let me say the question differently. If he goes to trial, he's going to trial on 4 Class A felonies.
Yes.
None of them are time-barred.
No, they are not.
Right. And we know from what transpired at sentencing, do we not, that the victim of the criminal conduct was available to testify. In fact, she did testify at sentencing. And what's very difficult for me on the prejudice prong, not on prong 1, is on what conceivable rationale with the victim in this subject matter, with this offense conduct testifying against you, do you have even subjectively determined that you want to proceed to trial on 4 Class A felonies?
Yes. Mr. Crowell was aware that the remaining felonies, the non-time barred felonies, carry a potential sentence of up to 220 years, that there are 4 Class A felonies that are non-time barred out of the 7 remaining non-time barred charges. But he still wishes, he wished at the time and still wishes now, 5 years later, to proceed to trial on those charges to vindicate himself of the charges against him, knowing full well.
But it's rational for going to trial. If you're moving from 210 years to 110 years, and you were a plea agreement for good time credit of 12.
Yes. While the plea agreement was substantially less than the maximum he faced, his preference is still to go to trial. His preference that he expressed even prior to accepting the plea deal was to go to trial on the charges. The plea deal, in fact, was not changed after his motion to terminate his counsel was denied. He only accepted the plea deal prior to that motion being denied because of the fact that he did not want to go to trial with his counsel, not because he suddenly got a more favorable plea deal that he thought was more agreeable. He wanted to go to trial initially on all the charges against him. He still wishes to go to trial on the 7 remaining non-time barred charges, despite the fact that it carries a long sentence. And as the Supreme Court and this court has said previously, the likelihood of success at trial is something that can be considered, but it is not the determinative issue. If a defendant has demonstrated a reasonable probability and it has expressed his or her preference to proceed to trial on the charges against.
Does the level of rationality of the decision affect our evaluation of how sincere he is in this expression? And I take your point that it's a subjective test.
Well, I think that Mr. Crowell's preference, it can be viewed in the context of the whole case and the case history in terms of the fact that he initially requested PCR relief. It's now 5 years later. He still wishes to face trial on the remaining charges. He actually has only less than 4 years remaining on the plea deal. Understanding that, still wishes to face the charges. I understand that the question is that doesn't seem objectively reasonable.
At least if he's highly likely to be convicted. Would you agree that if he were to go to trial and were convicted, the sentencing judge would be free to consider the entire course of conduct, including allegations that would be barred by the statute of limitations and uncharged conduct?
Yes, I don't have a full defense of Mr. Crowell prepared. I'm not in a position to make a trial defense, but I do understand that point.
Okay, Mr. Mann, you wish to reserve the remainder of your time?
Yes.
Okay,
Thank
very
you.
well. John, good morning.
May it please the court. The state court reasonably determined that Crowell did not prove prejudice. He could have gone to prison for the rest of his life, but accepted a plea agreement that called for 24 years in prison. He did not present evidence to show that his counsel's deficient performance made his decision to plead guilty irrational. Like the petitioner in Hill, he did not allege special circumstances to make the court think he would have gone to trial. And like the petitioner in Moore, his decision to plead guilty would have been rational, even if his counsel would have performed differently. The prejudice standard is subjective, so Crowell could have explained in his post-conviction affidavit why he would have gone to trial. He did not do so. He only alleged that he had learned about the statute of limitations later, and that made his plea illusory. But he never alleged that he would have rejected the plea agreement and then gone to trial, which he was required to do under Hill. The only evidence that the state court had to look at was Crowell's post-conviction affidavit and the pretrial hearing that happened 4 days before Crowell pleaded guilty. And that hearing doesn't tell us anything about what Crowell would have done had his counsel performed differently. At that hearing, Crowell was upset with his counsel because he believed he was misrepresenting what Crowell's family had said to the state. We don't know what happened between those 4 days when he said he wasn't pleading guilty and then he did. Maybe he spoke with his family. Maybe he learned that the state's case was actually stronger than he believed. We don't know, and the reason we don't know is because Crowell did not explain that in his affidavit. When this court reviews the state court's decision, it puts itself in the same position as the state court, meaning that the only record available to this court is the record that was available to the state court. And none of Crowell's proceedings after pleading guilty, after the sentencing hearing, were before the state court. His brief in state court wasn't before the post-conviction court. His habeas petition certainly wasn't before the post-conviction court. So anything that he has said later is irrelevant to the determination here. Without alleging any special circumstances that particularly applied to Crowell, the state court was left to ask, what would a reasonable person do in this situation? So the court reasonably determined that Crowell's decision was objectively rational. Even without the time-barred charges, Crowell still faced 220 years in prison. And right now he's projected to be released from prison 4 years from Wednesday. So it was an objectively rational decision to plead guilty, even had he known that 6 of the charges were barred by the statute of limitations. And I just want to briefly point out that when the court refers to contemporaneous evidence in Lee, what it's talking about is evidence at the time of the guilty plea hearing. So Lee is a blueprint for petitioners to raise a successful claim like this. In Lee, both the petitioner and his attorney testified that he would have gone to trial had his attorney told him that pleading guilty would make him deportable.
I mean, in Lee is a different. Lee, you have record evidence all along that the immigration consequences of a felony conviction were quite material at all points in time, being removed from the United States. Here, you have Mr. Crowell, who says he wants to would have gone to trial. So he lodges the conclusion, but at no point can I see how he ever connects it in any rational way to the time-barred charges.
That's correct.
He connects it to dissatisfaction with his lawyer on other fronts, and that's why the question I asked to Mr. Bannon, I keep coming back to how can you articulate a rationale for choosing to go to trial on all 4 of the Class A felonies? Forget everything else. None of them were time barred. And we know the victim was available to testify.
That's
So-
correct. Yes, and because it's so difficult to even think of what the special circumstances would be in this case, it makes the question of what would an objectively rational person do even more salient. It makes the state court's decision that much more reasonable. Crowell,
I guess, can I ask you to address a case that was cited by petitioner but not addressed in your brief, and that's Pigeon against Smith. I don't know if you focused on that or remember it or thought it was irrelevant.
I know I read it and I probably thought it was irrelevant because I didn't put it in my notes, but I'd be happy to try.
It happens to all. It's a similar sort of second thoughts about a plea based on what we will assume was ineffective advice, and our court's opinion affirmed a grant of habeas relief. In essence, on the theory that even if it wouldn't have made that much sense for him to go to trial, that was his choice. He could have done it. And I guess my question is that at one level that sounds like a credibility question. And my question about the rationality or irrationality of a choice would seem more relevant in a hearing rather than in deciding this on the papers. I'd like to address that.
Your Honor, if I remember correctly, was Pigeon about whether the petitioner was entitled to an evidentiary hearing?
Yes.
At which case the court wasn't directly addressing the merits of the claim. So I think what the court said is at this stage, what the petitioner has alleged is enough to get an evidentiary hearing. But it didn't.
I think the question was whether they could go forward in the hearing without the lawyer. And relief was granted without the lawyer having been present, and we affirmed that.
Okay.
Okay. I guess, but my problem here, I guess, is the extent to which we ought to decide this, the prejudice question definitively now, or whether he's entitled to hear.
He wouldn't be, and of course he would have to overcome the 2254E2 hurdle for a hearing, which he certainly can't do. He had an opportunity to present this evidence in the state court, and he didn't do so. Unless this court has any more questions, I'm happy to rest on my brief.
Okay. Very well, Mr. Drum. Thank you. Ben, you had a couple minutes left.
Thank you, Your Honors. I can be brief. I'm happy to answer any questions, obviously. I just have really 2 points that I'd like to make. The first is to address Judge Hamilton's reference to Pigeon v. Smith. I'd also like to point to the DiBartolo case, which also was not addressed by Appelli in the brief. In that case, the court recognized that the defendant, quote, wanted to roll the dice at trial, recognizing that his chances of success were very low, similar to Lee. And the court said, DiBartolo unquestionably wants to roll the dice, which is strong evidence that he would have chosen to roll the dice 4 years ago had he known about the deportation threat. He faces the same risk of conviction and long sentence now that he did then. And I think the case here is very similar, even though Mr. Crowell recognizes the long sentence that he faces, and it might seem objectively unreasonable to go to trial given the fact that the record contains the evidence that might be presented against him, that he still has expressed his preference to proceed to trial. And the second point is just the point that he never clearly explicitly stated his desire to go to trial in his pro se PCR petition. I think this court recognized, or this panel, recognized earlier, this was a pro se petition, and as this court has pointed to in other contexts, the clear import of filing this petition was to go to trial. He made that explicitly clear on appeal, and the Court of Appeals recognized that the process and the act of filing that petition was to request to go to trial on those charges, even though he didn't make it explicitly without the benefit of counsel and proceeding pro se. If the panel has no other questions, I'm concluded. Thank you.
Thank you. Mr. Bannon, the court knows you accepted this case on appointment to represent Mr. Crowell. We very much appreciate your service to him and to the court, and we thank your law firm as well.
Thank you, Your Honor.
Mr. Drum, thanks to you for your work. We'll take the case under advisement. We'll move to our fifth argument of the morning. Number 22-1967, Shelley Ellison versus the United States Postal Service. Okay, Mr. Falk, good morning.
Good morning. May it please the court. The issue in this case is whether Ms. Ellison has been denied meaningful access to the benefits of the programs of the United States Postal Service because she is in a wheelchair and cannot access the Shelbyville post office that has no ramp. The district court found that she had meaningful access in ways other than physically entering the Shelbyville post office. However, this is erroneous. The uncontested evidence in this case demonstrates that the only way she can obtain this meaningful access is if the Postal Service builds the ramp it had promised to build. And the district court should be reversed and the case remanded back for summary judgment from Ms. Ellison. Now, the district court held that she had this access required by 504 because she could use the Postal Service's website, and she and her organization could use post office boxes at very small towns that had post offices outside of Shelbyville. But the evidence demonstrates the obvious, which is that the website does not provide services comparable to those in person at the post office. There's no way to determine such things as the weight of a package, what postage to put on it, what sort of class of mail to use, or what sort of insurance to buy. Now, the Postal Service will send you packaging. It may take a week or so to get the actual packaging. Then you have to assemble it, and you still have to figure out what postage to add to it and how much it weighs, et cetera. And even then, you have to take it to the post office because they won't pick up a package that's more than 10 ounces, understandably. And while it's true that there are 3 small town post offices in other towns that have accessible post office boxes, the district court made no findings that these out of Shelbyville post offices had comparable services, and in fact rejected our motion, which was not opposed by the Postal Service, to supplement the evidence to show precisely that.
That request to supplement, though, came a year, did it not?
Yes, Your Honor.
After discovery had closed?
Yes, Your Honor. It came after a call with the judge, with counsel, where he indicated that he wished to have further information about those post offices, and he specifically asked during the call whether we knew if they provided comparable services. And as we note in docket 47, my co-counsel, Ms. Pachter, had actually been to one of those all those 3 post offices, and said something, but we obviously felt it was appropriate to supplement that with an affidavit from someone other than counsel.
The only point of my observation is that it's hard to see that as an abuse of discretion on the district court's part not to accept a filing like that.
I agree completely, and we have not argued that it is, because what the district court said was, I don't care about those other post offices except insofar as they have post office boxes. So we are not arguing it should be reversed on that grounds. We are just saying the court had the evidence if it wanted to, but it understandably did not use it because it said we're only looking at the post office boxes. But that does raise an issue. These towns are between 15 and 22 miles round trip from Ms. Ellison's home, and the idea of requiring a disabled person to leave their home community to get a service which is right around the corner for non-disabled persons, imposing that sort of temporal and other burden on them, is no different than putting a physical barrier in front of a disabled person and saying, it's okay, you can take this circuitous route that no one else has to take. It's not the even-handed treatment which the Supreme Court has held 504 demands.
Mr. Falk, is it the contention of Ms. Ellison that the central question here, in this case in particular, is that for the Postal Service to be able to give her meaningful access, they would have to build a ramp to the front of the Shelbyville post office?
They would have to build a ramp that made it accessible, right there, and that would be in the front. And that's exactly what they said they were going to do. Remember, the post office contacted the state of Indiana, an architect from the post office, along with a private architect, saying that the Postal Service is planning to install an ABA, Architectural Barriers Act, accessible ramp. It didn't say we're thinking about it. It didn't say we're looking into it. It said we're planning to do it, but for whatever reason, they did not do it. Instead, the post office had said to Ms. Ellison as an accommodation, we'll bring you the post office box mail mixed in with your regular mail. And while that may not be an ideal way to get your mail, it does nothing to get Ms. Ellison into the post office where she can actually visualize and get personal service and see what's there.
Can you explain, Mr. Falk, why she can go to the back door and wait, as I understand it. Why is she unable to go inside?
I believe, and
or should I ask Mr. Wood?
I mean, I can tell you what the post office say, and I don't know if this is in the record. That is a private space, and I think it's a position of the Postal Service that they cannot let people in that back door.
Okay, well, or they might face a lawsuit here. But is the Shelbyville Post Office accessible to employees who need to use a wheelchair?
I assume they have to go up that ramp, and that ramp is a ramp built originally for freight, and it still is. In fact, when it was being discussed being used for people, the then postmaster said it's really dangerous to have people out there because obviously we're moving back and forth. And Ms. Ellison's experience has been that she had gone to the post office. There's one accessible space. Because of all the trucks there, she actually was blocked into her car. She could not get out of her car. And the way the buzzer is set up, the buzzer is at the top of the ramp or at the front of where your car would be at the wall. So you physically have to get out of your car even to ring the buzzer. And at that point, you have to hope that someone comes out, and you have to hope that they're able to serve you, and you have to give them your charge card and your PIN, and you never get to see the inside of the post office. Not surprisingly, the district court found that the court had doubts that this satisfied 504, and not surprisingly, Ms. Ellison doesn't go to the post office. She goes to a private company in Shelbyville that she estimates is 3 times more expensive, but at least she has access and she can see someone.
Speaking of private companies, could you comment on how the solution of going to the next town over would apply, let's say, to a similar challenge to limited accessibility to UPS or FedEx or McDonald's?
Well,
the ADA?
Sure. I think that would be under Title III of the ADA, where there is more leniency in considering things like fundamental alterations and what have you. I think it's interesting you mentioned something like McDonald's. You go to McDonald's, you go inside, you go through the drive-through, you get your food. The thing about the Postal Service, as we all know from our personal experience, when we go to the post office, generally we're going there for service. We have a package, we have no idea.
Do you think McDonald's can say, if you're in a wheelchair, you have to go through
No.
the drive-through?
No,
you
not
can't
at,
come inside?
not at all. No, under Title
Or you
III,
have
I
to
think.
drive a county over to the next town?
No, not at all.
Absolutely not.
I did not mean to undermine the Title III of the ADA, but what I'm pointing out here is that it's even more problematic here, because the service we're talking about is more than, a better example is Amazon, is more than I get this piece of equipment at Kroger, or I get it at Amazon, it makes no difference. You go to the post office for the service, and Ms. Ellison cannot do that. She simply cannot do that.
Why doesn't the totality of it all, though, add up to be, yes, there's no question that she can't access it as she wishes in Shelbyville, but when you consider the totality of what is available, including the post offices in the neighboring towns, it's the ability to do online business. They drop the PO box off at our house. All that. Why isn't that enough to satisfy the standard?
How is Ms. Ellison going to send a package?
Drive 4 more minutes to the neighboring town.
No, Your Honor.
Go inside the post office and take your package.
No, Your Honor. And in fact, I mean, number one, the district court specifically said it wasn't looking at what those other post offices served. And number two,
Hold on. Okay, but there's no question that in the 3 neighboring towns, right, that they do have counters with lobbies and services that are offered by, a postal employee. It's very difficult for me to fathom that if there is a lobby and a window open, that you can't take a package to that window and mail it.
Again, this is not considered by the district court. It's in the record at 47-1. It's a declaration done by someone from Ann D'Angelo, who went and looked at the post office. In two of them, the two closest to Ms. Ellison, there was not packaging available. And the third one at Fairland, which I think was the furthest away, there was a limited amount of packaging. And of course, these post offices are open less hours. One of them's only open in the morning. So it is a burden, and it is, as I said, it's between 15 and 21.
What in your view, as a matter of law, is the degree of the burden, the degree of the inconvenience that the statute permits? Because we know it permits some.
I think the question, and I think you indicated, the question is totality. Is there a denial of meaningful access? And if in fact Ms. Ellison is not able to pick up something and drive to the nearby post office, enter the post office and mail it a package and get the advice of postal employees, I think that is a denial of meaningful access. And when you combine that with the fact that these other post offices are between, as I said, 15 and 21 miles round trip from her home in tiny towns, the largest is I think 804 population, that she would never ever go to.
You have to look at the delta though, right? The difference, because she already drives some distance, or she was driving some distance to Shelbyville, to the Shelbyville post office.
A little bit more than 5 miles, I believe.
Okay, and so then you have to look at, well, what's the additional travel she'd have to undertake?
Except Shelbyville's her home. Shelbyville is where she runs errands. Shelbyville is where she is. You're telling a disabled person, look, you have to go out of your home. You have to spend however long it takes to go the 15 to 22 miles. You have to figure out when the post office is open. You have to see if their services are any way comparable, and I do not believe they are. And then you have to leave your town. And I think that is more, I think the Second Circuit talked about a de minimis temporal burden. That is more than de minimis. And that's not something that's anathema to 504. 504 requires even-handed treatment, and that's not close.
I wanted to take a minute, Mr. Falk, and look at the briefing here. So the court assumed or accepted the proposed, I believe, declaration, the footnote you directed us to. The evidence only established certain retail services, going back to Judge Scudder's point, as to the services that were provided. Was there a distinction of the services that she would have received at the Shelbyville location that was not accessible at those other locations?
It's my understanding, and again, I have not been to the other locations, but it's my understanding that Shelbyville Post Office has a uniquely large number of packaging options, both the post office type packages as well as holiday theme packaging. It's gift cards. It has greeting cards. It has the ability to purchase various items, scales, I think. It has everything that most of us look for when we go helplessly to a post office with something to mail, because we have no idea what we're doing. And that is something that now Ms. Ellison pays 3 times as much for by going to a private space, because she cannot get into the post office. And again, the post office said it was going to build a ramp. We're not dealing with impossibility here. We're not dealing with a lack of proportionality, which is required for us to demonstrate our prima facie case to show a reasonable accommodation. They said they were going to build the ramp, and they didn't build the ramp. And I think we have to remember we're in 2023. The Architectural Barriers Act was in 1968. The Rehabilitation Act was in 1973. The ADA was in the 1990s. We shouldn't be here today talking about a ramp. Build the ramp. And again, as we noted in our briefing, I understand the post office says they could not do it. Shelbyville offered to pay for the ramp.
Is it your position, Mr. Falk, that all 34,000 Postal Service facilities need to be wheelchair accessible?
No, Your Honor. It's my position that we have to look at each case to see if there's meaningful access. One could certainly theorize a situation where there might be meaningful access with something more closely proximate in your neighborhood to neighborhood post offices. One could foresee that. I would dare say, however, given that the ABA was in effect in 1968 and applies not just to new building, but to improvements or rental of property, there are probably very few post offices now that are not accessible. I'm sure there are some.
They have to be accessible for employees.
They have to be accessible for employees, and you would think the post office would not want their employees to suffer the danger of going in through a freight entrance. Thank you.
Okay, very well. I'll give you some rebuttal time, Mr. Wood. Good afternoon.
Your Honor, may it please the court, Bob Wood on behalf of the United States Postal Service. If I may, a couple of points of record clarification, and I think there's some room for disagreement on some of these things. The Postal Service did not promise to build a ramp. It would be difficult to characterize that as a promise, given that DLZ's characterization of this as a plan came 6 months after the filing of the lawsuit and was part of an effort not to build the ramp. So even though they use the word planning, which is, I think, the architectural language that they were using to prompt the historical study, characterizing this as a promise when it was part of the litigation and regulatory effort not to build the ramp in the first place. And we can get to the questions of build the ramp or don't build the ramp. When Ken said build that ramp, I was afraid that the whole place was going to erupt into a chance of build the ramp. But I understand the nature of that desire. And then also on the record, weighing and postage, packaging of certain types are all available at the other post office locations. However much farther away they are in minutes.
Hold on. I thought Mr. Falk's point is that as a matter of record evidence, what we know is that the 3 neighboring towns have post offices. We know that those post offices have counters that are open to customers.
Right.
And you know, I mean, but we don't know a lot beyond that.
Right. What retail means, we don't know. But all I meant by that, and I think he said this as well, is that at Fairland, which is not proximal compared to the other locations, there is some retail packaging and tape and some things available at that one. What retail means with respect to packaging at the other 2, I can't say. He can't say. That's not part of the record.
If the Postal Service were to build a ramp here, would they have to use GSA to do it?
I believe the answer is correct. Yes, but I don't know. I can't say for sure.
Wood, can I ask you? You got 34,000 facilities. You tell us. How many of them are not wheelchair accessible to employees?
It's not in the record, but I think they are all accessible to employees.
And how many are not accessible to customers?
I wouldn't want to venture a guess. That is the closest thing in the record to that is in the Mr. Del Hierro's deposition. He talks about there are all these issues the post office is facing at all these facilities, and we only have funds for emergencies.
Mm-hmm.
That's the closest to national budgetary concerns the record comes.
So the defense here, you know, in essence, you go to the drive-through window, or we'll come pick you up, or you can go to these other towns. Your office enforces the ADA against private businesses, right? Would those defenses be accepted from UPS or FedEx if they said our main office in the county is not accessible, but you can go to these other places?
Without wanting to speak to future litigation, I don't think I think mostly those cases in our office have settled in favor of accessibility.
Yep.
Or
because that's what the ADA requires.
Sure. And to that point, this is not this is what would be under the ADA an existing facility case. It's a non-Barriers Act case. The standards are different. Program access is the standard. There are cases out of the Fifth Circuit and the I'll think of it. It might be the Ninth Circuit that say to force facilities access in a case like this would render null the.
Well, the Ninth Circuit case is the one about San Francisco parks, right?
And then there's the football bleachers.
The football bleachers, but I take it you would not argue that adequate football access would be, well, you can go to the away games. You can keep the home field inaccessible, but you can go to the away.
Well, in that sense, the school that would be on the bottom of the caption wouldn't even be the one providing access. In that sense, right? It would be the other school system.
It could be different high schools in the same system. Sure.
Yeah. Fair enough.
Okay. Would a school, under the Rehab Act, could a school system say, we're just going to have one of our schools in town be accessible? And we're going to make all the kids who have wheelchairs go to that school? I can't imagine.
I can't imagine. I think one of the limitations here, and Mr. Falk spoke to this, is because of lease turnovers, other structural changes that have happened, there are so few facilities left that would fall under this existing facility ADA standard or non-ABA federal facility standard that there just aren't a lot of cases on this subject. And the question of whether a school system could do that, I think any school system, before getting to the final answer on the absolute hypothetical, I think any school system will have made sufficient changes that those program access standards won't apply. Technical compliance, physical facilities access standards will apply. So it would be a different law. If you had, strictly speaking, a school system where they had made no structural changes since 1968 or 1992, it would come down to the nature and degree of the burden placed on the student.
Okay, so let's go there. If we were to say this access is good enough, comply with the Rehabilitation Act, where do you think it would become intolerable, unacceptable? If the driving time were 20 minutes longer, 30 minutes, would it matter whether we're talking about Greenwich Village or Montana?
I think, and I alluded to that in the Postal Service's brief. I think that would require a record on what average times are for people who do not require a wheelchair specifically in the United States, to see what uniform standards there are in terms of people's expectations for service from the Postal Service. There's the initial check of, does this seem right? I take Your Honor's point there. I wouldn't want to give a fulsome answer on behalf of the Postal Service without understanding what some people in places like rural Montana, or I mean, really anywhere in the West, or maybe in the rural South, might expect from the Postal Service, who are, to be clear, persons without disabilities.
Mr. Wood, there's one aspect of the litigation that I wondered about, and that was the point that the Postal Service is taking is that given the totality of the access available through these other measures, including the 3 other locations, that suffices for purposes of access to the programs and the services that the Postal Service offers. And of course, that's being balanced against the cost of installing a ramp. The Postal Service, as I understand it, took the position in the litigation that whatever cost estimate it received was confidential and subject to work product protection. Why would the post office take that position? Why wouldn't the post office be as transparent as it possibly could be with the cost estimate and say, "We'll send you a copy. Where do you want me to send it to?"
So what I can say is what's in the record about that. I joined this case for appeal purposes, but that work product privilege was asserted with respect to settlement negotiations.
Oh, I got that, but there's an aspect of this where the post office has some idea of what it would cost to install a ramp. And the reason, I'm not trying to draw it out of you here. I know that we're not litigating work product protection. I got that, but it would seem to me that it could come in a pretty minimal cost, or it could come in a much more significant cost. Part of it depends upon how much work you want to do to the exterior of that building, or do you just want to bring in a more temporary but safe ramp for people to access just on the side of the stairs?
What I would
I don't understand the it's confidential point at all.
I think that my understanding of this is that the work product privilege was asserted and was never and has yet to be relinquished, but that if this matter went to trial, costs, as Van de Zand says, come in twice. So you have to have evidence. I mean, I don't know if you even get to an undue hardship defense on a Rehab Act case necessarily, but costs are central to the evidence under Lane, under any assessment of the regulation, the Rehab Act regulations. So those costs would have to be part of a trial.
Yeah, and the post office has a lot of experience with putting ramps in. Tons of experience. It's just a very odd litigating position to me.
And it is the case, I think, that if the, because we don't know, let's say it is a less expensive than the rear ramp refurbishment, that might suggest one result. If it's far more expensive, and you take into account the fact that understandably for Ms. Ellison, this is a Shelbyville case. For the Postal Service, just as understandably, this is however many non-ABA, no ramp post offices there are.
Let's also understand that it's also not just about Ms. Ellison. Right?
Of course.
We've got, the CDC says about 11% of adults have serious difficulty walking or with stairs. It's 25 million postal customers.
The cost question would have to be part of a trial, regardless of any desire for confidentiality. I can't imagine a trial.
And presumably discovery would have to be reopened for that.
Yes, and the Postal Service maintains that it would be relevant at 2 stages, not just at the affirmative defense stage.
On the back door option, is the back door sheltered from weather?
From the photographs, I know there was some discussion of weather exposure prior. It's not sheltered from the cold. I think it's sheltered from precipitation, but it can get quite cold.
You think yes, and you think you can get out from the rain there. I've got to say that this has a clear flavor of Jim Crow applied to folks with wheelchairs. There's wait at the back door for us to come in response to. I understand that the Shelbyville post office folks may be doing the best they can given national funding priorities and so on, but sense of discrimination, which by the way is the standard, is one of the statutory standards. Meaningful access is a passing phrase for this for very different contexts. I'm very troubled by this.
And what I can say in response to that is that the Postal Service views its alternate locations as the primary means of accessibility in this case. And believe me that I understand.
I understand that the district court wasn't too overwhelmed by the back ramp.
No, but one thing that this is another record clarification issue. My understanding of the safety concern relates to when there was, and I may be wrong about this, but it was when there was just one buzzer and the buzzer put a person in a place where they could get hit by the door on exit, and that's why the second buzzer was added to avoid that safety concern. And I understand the rejoinder will probably be that buzzer is not an ideal location either, but that was part of the effort to become, because the rear of the building is subject to the Architectural Barriers Act, and to come into compliance with that, the buzzer was moved.
Is there a distinction? I'm sorry.
Go ahead.
Is there a distinction between meaningful access and equal access?
Well, Corolla would certainly say there is, as an example, the Ninth Circuit's case saying that numerous marquee attractions in San Francisco's, most iconic park are not wholly non-accessible, but the program access standard was met by the city in that case, and that's clearly not equal access. So there would have to be some substantial distinction.
About that third option, the website? Seems a little dangerous to me to set the precedent suggested.
The Postal Service does not take the position in this case that the website is sufficient on its own. It is more robust, I think, than has been characterized. First-class mail is available through Click and Ship. There are. I think the only thing that Ms. Ellison, if you took a holistic view of what is available to her and you stripped out burdens, and I get the burdens are essential, it's gift cards. Gift cards are not available on the website. They're not available. There seems to be no way, however you read the record, that they're available at the smaller post offices. Greeting cards, certain envelopes. There are gifts on the website. There's everything else like that. But the website alone is not. That's not the litigated position. With that, I'll rest on my briefs. Thank you.
Okay, very well. Mr. Wood, Mr. Falk, why don't you we'll give you a minute on rebuttal.
Thank you.
Round it up.
Thank you.
Oh, no, you had a minute 32? We'll give you 2.
Well, speaking of rounding, Your Honor, if we look at the other post offices, the closest one to Ms. Ellison is the Waldron Post Office, which is 15.4 miles round trip. It's open 32 hours a week as opposed to the Shelbyville, which is open, there's a dispute, either 45 or 47.5. The Manila Post Office, which is 18.4 miles round trip, is open 22 hours a week. The post office in Fairland, which is the furthest away, almost 22 miles, 10.9 miles one way, is open 41.5 hours. So there's not this equality of service. I think the meaningful access standard allows an entity to apportion services, get this from here, get this from here, get this from here. It's not ideal, but you still have to add up to meaningful access. And the problem here is that when you look at the website, you look at the RAM, and you look at the post office boxes, whether it's delivered to your home or going to these out-of-town post offices, you don't get close to meaningful access. You don't get close to the experience that Ms. Ellison now is paying 3 times for by going to a private company where she can wheel in, get advice, get a package, and deal with it that way. And I think all of us see the post office providing that service. And the post office said in a statement to the state of Indiana, we are planning to install this ramp. And I don't think it can back away from that now. And it certainly never argued in the district court. It never raised an undue burden defense, and it can't. And it would be silly to raise an undue burden defense. Despite its financial problems, it did have revenue of $73.1 billion in 2020. It's time to build the ramp. Thank you.
Well, thanks to you, Mr. Wood. Thanks to you as well. The court will take the case under advisement. We'll move to our final argument of the morning. Okay, our final case of the day is appeal number 222486, Carolyn Bridges versus Blackstone.
Good afternoon, Your Honors. May it please the court, Kyle Schamberg on behalf of the plaintiff's appellants. I'm here asking the court to reverse the district court's dismissal of the plaintiff's amended complaint without prejudice. Plaintiffs here have alleged that the defendant Blackstone violated the Illinois Genetic Information Privacy Act, JIPA, as part of its...
Let's refer to it as the Act, okay?
Sure, I didn't know if I would go with GIPA or JIPA. The Act is fine.
Acronyms this morning.
That defendant violated the Act when it compelled the disclosure of plaintiff's genetic information as part of its acquisition of Ancestry.com in 2020. In
With the district court, that there was a need for a requirement that Blackstone compelled something.
Yes, there is Section 15 of the Act also discusses the release of information, and there were some allegations that dealt with the release of information, but the issue here certainly before the court is the compel, Section 30, and the definition of compel. And what the district court did on that issue and on another issue that I'll get into is it drew reasonable inferences and construed the factual allegations that were made against the plaintiffs. And it did so on 2 broad points, the first being the definition of the word compel. And the district court set up a definition that I don't think is incorrect and that the district court noted the parties agreed on. And that was essentially that compel requires more than the passive receipt of information, and it requires more than simply asking for something. But what the district court incorrectly did, I would submit, is find that the plaintiff's allegations didn't plausibly allege that that had occurred. And I would suggest that they did at paragraphs 27 and 28 of the amended complaint, which is where I would start.
And
and
what's
note
the definition of the appellants to the question regarding compel?
it would be to influence or oblige someone to do something in a manner more than simply requesting or asking for that. Be exerting some influence over someone to take an action.
Where are you basing that definition or pulling that definition from?
The generally understood definition of compel. I know the plaintiffs below the district court had offered a dictionary.com definition. That's the one that we use. And there were a few other ones that are referenced.
The definition from dictionary.com, though, is to force or oblige someone to do something.
But then it also talks about influencing, force or oblige.
And the second definition under dictionary.com is to have a powerful and irresistible effect, influence, etc. And it seems you've pulled from that language a different definition.
Well, there's definitions that focus more, I would say, on what is the strongest interpretation of compel, and that is to force through threats or overwhelming pressure. But these definitions also talk about obliging a person to do something, let's say, influencing or obliging. And I would submit, Judge Pryor, that Blackstone did influence or oblige Ancestry to transfer the data. And here's why I would suggest that we've alleged that. In the Bloomberg article from which we pull some of our allegations and which cite to the regulatory filings, there were two statements that Blackstone had made publicly 11 days after it completed the acquisition of Ancestry.com. One was that it was preparing to package and sell data from companies that it acquires. The other is that Blackstone already has information sharing and usage agreements in place that permitted to obtain data from portfolio companies owned by its funds. So at the time Blackstone acquired Ancestry, and as we alleged, it was enacting a business plan of acquiring entities in order to gather, obtain, and then monetize their data. And that makes sense here. Ancestry.com is a very profitable business. That's a very proprietary data set of genetic information. It would make sense that Blackstone would want to acquire that as part of this publicly stated business strategy. And so we've alleged that as part of this strategy and as part of the deal that Blackstone made with Ancestry, they required Ancestry.com to transfer that genetic information to them. Now, to them? Blackstone. Blackstone acquired the, yes.
So let me ask, what was the form of the acquisition? Was it an asset sale? Was it a stock deal? Was it a merger?
It was a merger. It was an acquisition, but
does Ancestry.com Inc. still exist? Then?
I believe that it does.
I would suggest it's a stock purchase.
It may, yeah, but
go ahead.
I was just going to say, Judge, this is part of the difficulty that we have because this is a private equity transaction. We don't have access at this stage pre-discovery to all the terms of the deal and what was required. However, based on the fact that Blackstone was acquiring data from the companies that it purchased, it is reasonable to infer, and I would say it would be unreasonable not to infer, that as part of the deal that was structured between these companies that we don't have access to. Blackstone said one of the terms of the deal is you're going to transfer this data to us. That's not pulled out of nowhere. It's pulled out of what they had said they were going to do publicly.
So let me try. My question in essence is whether it's just the change in control that you think is sufficient to show a violation of the statute, Section 30.
I believe that if Blackstone took control over Ancestry, kept Ancestry.com as a separate, let's say, subsidiary, separate entity, but gained access to the information, that information was therefore disclosed to Blackstone, regardless of what the form.
So change in control is sufficient, in your view, to violate the statute?
Yes.
Okay, so what happens, suppose you got information protected by the statute that is in the control and ownership of a human being, files, for example. That human being dies and control passes to his estate. Is that a violation of the statute? Now the executor has it.
Yes, because the genetic information can only be disclosed to people who are specifically authorized by the person whose information is
So
obtained.
by dying, he has violated the statute.
You're talking about that human being who died, his own genetic information.
No. He possesses a set of files. Maybe it's a document.
Of others.
Of others. Protected by the statute. He dies, and the files go in, or an asset of his estate. That's enough.
Absent the written authorization of the person whose information was affected, it would violate JIPA to disclose that information.
In your reply brief, you suggested, if I understood you correctly, that Blackstone violated the statute by even making the offer to acquire.
Well, that would fall under the concept of, that would be more of a Section 15 argument, which we did mention in the reply brief, but for the release of information causing the release. I'm sorry, Judge. So
Can I ask you a question before I know you want some rebuttal time here on, you don't spill nearly as much ink in your briefing on the argument that your adversary makes about the recipient of information facing liability. What's your best argument on that front, that the language even fits this circumstance?
I think it's similar to the district court's reasoning, Judge Scudder, in that when it says disclose or be compelled to disclose, that I think would.
It's a lot different though than saying no person may compel. Right? I mean, I have a hard time seeing the fit.
Yeah, I think it would be protect.
I understand your argument about compel itself. I'm just not so sure the recipient's covered here.
I think it's intended to cover, based on the fact that the statute discusses the release of information in Section 15. When it talks about 30, it talks about requests for in Section 5. It's clearly contemplating entities that are looking to obtain this data. And those sections would imply to me that the be compelled is having it apply to the recipients of that data. Otherwise, it would be superfluous because it's already prevented the company who owns the data from disclosing it.
I think we should take any stock at all of the remedy of a preliminary injunction being made expressly available by the Illinois legislature in this statute. The only context in which a preliminary injunction makes any sense to me is that the plaintiff is trying to stop the defendant from doing something that the plaintiff believes is going to lead to some kind of legal harm, right? That way.
Yes.
And so a preliminary injunction only makes sense to me in the context of thinking about not the recipient, but the would-be discloser. Ancestry.com on this fact pattern.
It certainly would apply in that case, but also if the plaintiffs had been informed, and it's one of the suggestions that we made, if prior to the culmination of this deal, if Ancestry.com had said, we are going to release this information to an acquiring company, you have 60 to 90 days to determine whether you want to keep it or delete it, the plaintiffs would have been able to pursue an injunction there to stop it from happening if they would have said, we're not going to destroy the data, we are going to transfer it.
It looked like there may be some case that's been brought against Ancestry.
There is a case directly
arising
against
out of this
Ancestry.
transaction, it seems. That way, right? So Ancestry will argue what it argues, and plaintiffs will make whatever argument. But here we don't have Ancestry. We have the acquiring company.
Yes,
Blackstone.
and I would say that the plaintiffs would have an opportunity to, in that case, to pursue a preliminary injunction against Ancestry, but they also, based on the language of the statute, are able to pursue a case against the company that's compelling the disclosure, in this case, Blackstone.
Okay, let's hear from Mr. Roth. We'll give you a minute on rebuttal.
Thank you, Judge.
Yep.
Good afternoon, Your Honor, members of the panel. May it please the court, Martin Roth on behalf of Blackstone. The issue on appeal is whether the district court correctly dismissed plaintiff's class action alleging that Blackstone violated the Genetic Information Privacy Act merely by buying Ancestry.com in a stock purchase. The answer to that must be yes, for the reasons a lot of Your Honor's questions have already hinted at.
It was a stock purchase?
It was a
How
stock
do we know
purchase. It's in the press release that plaintiffs cite and attached to their complaint. It talks about a control transaction. So The act here prevents companies that possess genetic information and genetic test results from releasing or disclosing those results to third parties. It does not prevent investment firms like Blackstone from buying companies that lawfully possess genetic information. And in fact, as we've cited in the debate over the act, the Illinois legislature talked about promoting genetic testing for things like law enforcement, disease prevention, et cetera. So clearly they wanted to allow for genetic testing, not hinder it, and preventing these sort of basic transactions that cause investment in companies that have genetic information would be against that policy. In addition, as your honors are very familiar, Illinois has another statute called BIPA, the Biometric Information Privacy Act, which has spawned tons of litigation. And in that statute, that language expressly prohibits obtaining or acquiring biometric information. So the words of this statute are different. Illinois legislatures understand how to pass laws that prohibit this sort of conduct, and they did so in BIPA, which has been amended during some of the same legislative sessions during which the act here has also been amended. So,
Roth, let me ask you about the compel point. Okay, sorry to interrupt your train of thought there, but the reason that I have difficulty with your compel argument and benefit from hearing you push back on this is that it seems that your client, at least as alleged, may have been under a contractual obligation in the deal. As alleged, I know may turn out to be different factually, to transmit protected information, with the obligation being one of contract. And it doesn't seem odd at all to me to think of a party being compelled to do something by contract. Now, to be sure, a contract is not a use of force or anything like that. But one common, you have to pay money damages for breach of a contract, specific performance can be awarded to fulfill contractual obligations. It doesn't seem a stretch at all to me to say that Blackstone was compelled here.
So two responses, Your Honor.
Ancestry. Yeah.
Two responses. So the first is a point you were getting at in the questioning of my colleague, which is the statute doesn't say compelled, it says be compelled. And I take that the access—
It's a different point. That's right.
Right. But
We'll get to that.
Okay. So on the compel point,
right.
I think that it would have been very easy for the legislature to write something like contract, acquire, purchase. They do that in GIPA. They don't do that here. And when you look at the dictionary, a business transaction, which is generally considered a voluntary arm's length transaction, even if it results in a contract, wouldn't be considered compel under the dictionary definitions that we provided.
Suppose the deal, I'm not asking you to disclose anything you shouldn't disclose. Suppose the deal is structured in a way that Blackstone acquires protected information. Okay, the genetic profiling, the results of testing, it links to individuals by name, by date of birth. So let's just stipulate that it's protected. And after you close the deal, Ancestry refused to transfer the files. It would seem to me that your client would be in a pretty good position to say, look, you're contractually compelled to do that. That's a term of the deal here. So you're either gonna have to do one of two things. We're gonna have to unwind the deal. We either want rescission or we want specific performance.
So first, to be clear, those are not our facts. Those are not the terms of the deal, and that's not pled.
Well, I don't know whether they are or they're not. I'm not interested. I'm just trying to get a hypothetical to you to try to figure out what's compelled here.
I think if Blackstone took the affirmative step of going to court and the court entered an order saying that that was correct, then they would be compelled by force of law. But the existence of a provision in a contract alone is not compelled under the dictionary definitions or the case law we cite. In fact, we cited the Washington versus Meacham case from the Connecticut Supreme Court, which looked at a very similar statute and said that it's only where real physical or moral compulsion from an external source is placed on a person does that satisfy the definition. So I take your Honor's point. I think, we could theorize a lot of situations where there might be compulsion by force of law, but that's not how courts or the dictionary interpret the term present in the statute here. Now, on the point of to be compelled, we don't have to win that point. Judge Dugan actually rejected it, but I think that the passive voice is important because the legislature certainly could have written a sentence.
They could have done it. They could have been more specific, but under your theory, what work does that clause do?
So I think the work it's doing goes to Judge Scudder's question, right? So one of the things you can do under the statute is get an injunction to prevent a party or require a party to disclose genetically protected information. And if you look at the totality of these two sections, section 15, which they've waived any argument about, it's not in their appellate brief, the opening brief, or in the district court, and section 30, you see what I'm talking about. So section 15 talks about the confidentiality of genetic information and has a whole laundry list of definitions as to how it's confidential, how it can be used in law enforcement, health, etc. Section 30, the operative provision at issue here, says no person may disclose or be compelled to disclose the identity of any person upon whom a genetic test is performed or the result of a genetic test in a manner that permits identification of the subject of that test, except for the following persons. And there's a whole list there, things like people designated authorized agents of a health facility, health facilities, etc. And so I think when you read those sections of the act in connection with each other and with section 40, what the legislature is doing is they are saying, in general, this genetic information is confidential. You can't disclose it, except sometimes you can. And courts, when you're looking at this act, you shouldn't compel people, unless they fall into these categories, to disclose that information. The Illinois legislature modeled this statute off of the HIV Protection Act, which has a similar clause. So far as we can tell from the archaeology of this legislation, Illinois took a statute on the books, basically modified it to apply to genetic information, and is more directing courts, whether they're state courts or federal district courts, to comply with the mandates of that act. Just to address a couple of points, unless your honors have specific questions on that, I think it's clear from the dictionary.
Talk about the Privacy Act.
What was that, Judge Breyer?
Yeah, can maybe talk a little bit more about the Privacy Act that was in play at the time this case was taken up. It said it will share this information if it's a
privacy statement. Yes. So a couple things on that. That was a privacy statement on Ancestry.com's website. At the time the case was filed, Ancestry, before it had even contemplated any specific Blackstone acquisition, for 10 years, had a statement on its website saying that it would share information in the event of an acquisition. Number one, that shows Ancestry wasn't compelled, right? Because it voluntarily was thinking about doing that long before Blackstone came in the picture. But that statement was subsequently modified to say that it might share the information. And the other document that plaintiffs cite in their complaint, which
so did they change that before the acquisition?
I think it was changed around the time of the acquisition at the end of 2020. I believe before the acquisition, it still said will share, and then it changed subsequently. But the other statement that plaintiffs cite in their complaint is this Bloomberg News article. And when the court looks at that, it becomes very clear why Judge Dugan reached the conclusion he did, because it has nothing to do whatever with ancestry or genetic information. It talks generically about how private equity firms like Blackstone and hedge funds like Point78 might start using data held by their portfolio companies to make investment decisions. And it specifically talks about Point78 using data related to the locations of Topgolf to decide to short the stock of Dave & Buster's. That's a totally different issue than what is at issue here. And when Judge Dugan looked at that statement and he saw that Blackstone actually said this was exploratory, no data had been transferred, and it was thinking about doing it in the future, he found that that also undercut the allegations of the complaint. So to summarize, there are sort of two issues here that I think make clear why this court should affirm. First, they haven't stated a statutory claim under any section. We move to dismiss all of the claims under the statute, whether 15 or 30. Their argument on 15 has been waived. Their argument on 30 was explained by Judge Dugan when he explained the definition of compel wasn't satisfied. But separately, and this is critically important too, this case was dismissed without prejudice. Judge Dugan gave the plaintiffs the opportunity to amend their complaint and to allege more. And rather than do that, they just waited and filed an appeal. Under Iqbal and Twombly, they haven't alleged plausible allegations showing any sort of compulsion or transfer. Despite the opportunity to do that, they had no facts to do so, so they didn't. And for all of those reasons, this court should affirm.
Okay, very well. Mr. Schomburg? Give you a minute on rebuttal.
Thank you, Judge. Just a few quick points, absent any questions from the panel. Mr. Roth mentioned that JIPA wasn't intended to stop the mere acquisition of one company by another, but that's not what this situation is. This is a situation where Blackstone acquired Ancestry with the stated intent of obtaining and monetizing the data that it had, including genetic information. Those facts were plausibly alleged. It makes it different from just a mere market transaction otherwise. Mr. Roth also and the illustration that Judge Scudder brought up about a preliminary injunction, and that if Blackstone lost in court and was compelled by law to share the information, that would constitute being compelled. But to the point of statutory economy, the statute doesn't say compelled by law. It easily could have. Compelled shouldn't be construed that narrowly to mean, say, a court order or law enforcement action or anything like that. Finally, in the privacy statement, in terms of Ancestry saying that it will share the information, I would submit that that goes to, again, show the plausibility of the allegation that the data was transferred. And also, it doesn't mean that even if Ancestry said we will share this, if part of the deal and part of the contractual obligation, as Judge Scudder mentioned, meant that Ancestry did have to follow through on that offer, then that would still be compelling the disclosure of that information. Ultimately, however, though, we're at the pleading stage. The plaintiffs have plausibly alleged reasonable inferences that can be drawn from these facts, and we should at least have the opportunity to go into discovery, even if your honors aren't sure if they will be proven ultimately or not. Thank you for your time.
Okay. Thanks to both parties. The court will take the appeal under advisement. That concludes the day's arguments, and the court again renews its thanks to McKinney Law School for hosting us today. It's been a real pleasure to sit. Thank you.